Morning, everybody. Welcome back to day 3 of the Trump disqualification trial in Colorado. Court is not underway. I do have it open. I also have backup links, which I've not yet tested. Judge is about to walk into the room. There's gaveling there, implying that all should rise. Just the way things happen. That is the way things happen. At some point today, I may be hooking up with others. We'll see. And I'll share with you where we are at here, so you can feel confident that we're on top of things, that we're not falling behind. We're not falling behind. That is the courtroom right now at 8:05 in the morning in Denver, Colorado. Judge Sarah Wallace. While we are here, I want to remind you what this judge thinks this case is about, because this entire thing is a very weird type of hearing, right? This is a hearing for the judge to decide what she's going to do with the case. And, I was looking around on this case. I figured, I'm investing some time here. I should probably let my audience know exactly what are the factors that she's looking to decide in reaching her determination. Like, what does this judge want? And a little bit more about this judge. This judge, by the way, to point out to you, she refused to recuse herself, despite the fact that she gave $100 donation 3 days before she was appointed a judge. So on Friday, August 18, 2022, she, I believe that was the date. She gave $100 to an Act Blue organization called Turnout Colorado, which was an organization that was formed in the reaction to the Republican Party failing to renounce Trump as a candidate because of because he's engaged in insurrection. She gave $100 to that organization. 3 days later, the public was notified that she was going to be an incoming judge in January 2023. She obviously knew about this at the time, got her donation in time. Trump brought a motion that she should be recused because of this clear bias wherein she's giving money to organizations that are helping to stop insurrectionists from taking over, because Lauren Boebert and others were considered a threat to society for the support of January 6th. And in denying the request to recuse herself, she alleged that she's not biased because she didn't remember giving the money. And it really wasn't that big a deal to her. Now, $100, she was working with Ballot Spar, which is a big firm. I'm sure $100 is not anything that she would have sweated over. It's not like it's $100 to most people. Ballot Spar is a big firm. I'm sure she was being paid many thousands times that in Ballot Spar. An incoming associate in Ballot Spar probably makes $180,000. She gave $100. She's been practicing law for the last 25 years. I'm sure she probably makes closer to 7 figures than she does to 100,000 when she was working in Ballot Spar. So $100 to her is not something. I mean, she probably was being billed out at a rate of closer to $1,000 an hour than $100. So it's not like it's a lot of money to her. That being said, she specifically designated when she sent the money to Act Blue to that organization. She said she didn't remember the organization even existed. Maybe it's possible. To her giving $100 there, what I'm saying is like most people giving like $5 somewhere. Anyhow, with respect to this particular case, what is it that she is looking to determine? What are the key factors here? And I found this site here, which I think laid out is best possible what the hearing is going to focus on. So I'll bring this up here for you. The focus is, how often does the Secretary of State exclude candidates? This is what will the hearing focus on? Provide the parties with a list of topics. Let's see what we got here. She had a list of topics. The matter is before the court to respond to. The following is a current list of topics the court would like to have addressed at the hearing set for October 30th. How often and what basis does the Secretary of State exclude candidates based on constitutional deficiencies? Okay. I guess that's a fact question. The process for drafting and approving the major party candidate and statement of intent, and who can revise or edit it. I'm not sure why that is. The other things that she listed is Section 3 self-execute of the how has Section 3 of the 14th Amendment been applied throughout history? That would seem like you sort of do legal research. You don't normally have a hearing. A hearing is supposed to be a fact-finding mission, not a law-finding mission. And the judge, is very keen about the distinction between a search for fact versus a search for law. So this seems like a weird thing for her to be requesting. She's also asking, is Section 3 of the 14th Amendment self-executing, or does there need to be a separate legislation giving it teeth? Presumably, I'm not sure. Presumably, if it's self-executing, in that case, there'd be no reason to keep her off the ballot. One of the things I haven't really discussed here is even if Section 3 would apply to president, to someone running for a president, and even if you could say that inciting a proposed insurrection is considered engaging in insurrection, and even if you say that this was an insurrection and that he incited, and even if you could say that his statements could be read as the cause of inciting it. And even if the language there, which seems to specifically carve out the office of president and the office of vice president, because it says any senator or member of the House or elector of a president or vice president, ... saying that cannot retain those offices if you have engaged in insurrection. Even if so, it seems to cut out president, because it seems to think about the president and say, we're not cutting out president, we're cutting out elector of a president from holding office if they engage in insurrection. And if you get past all those hurdles, who's to say that it's a state's position, a state's prerogative to say that its constituents cannot vote for this person, and then whatever happens after that is up to whether they actually can take office is a different thing. Meaning, what you're telling, this is a petition to get the Secretary of State to remove Trump from the ballot. Who says that's part of anything? Removal from a ballot. Why is that part? What, maybe they can vote for Trump, and then if the Congress or whomever, Supreme Court, federal court says you can't take office because of Section 3 of the 14th Amendment, well, in that case, whoever would fall in his stead is the person that these people are electing. But to say that a person is kept off the ballot, how is that tied in? Now, she has tried tying this in under a claim that it's the duty of the Secretary of State to make sure that the only people who are candidates are those who are eligible to serve. But that's a stretch of Colorado law. And then she asks also, these are the factors that we're trying to determine during the course of this hearing, which are really factors we need to be focusing on. Is Section 3 self-executing? Does there need to be a separate legislation teeth? What does it mean to have engaged in insurrection? Sounds like a legal question too, not a fact question. What are they going to start coming up with facts and like, oh, in 1854 on Harper's raid on Browns Ferry, like, what? That's going to be a legal finding as to engaging in insurrection. That sounds like something you sort of would look into historical past or the legislative. You look into legislative intent in the drafting of the 14th Amendment. Do research on that, which the courts often do without having a hearing. And does Section 3 even apply to former presidents, like I was asking? So these are the questions that she's looking to get from here. So we're flying afield into like having expert witnesses come in and testify about whether or not he had a legal ability to send in the National Guard to the Capitol. it seems to be quite a stretch from anything that she's looking for, and I don't even know what the heck she's asking for. Like, some of these questions she's asking seem bizarre. So I just wanted to tell you that these are the issues, the issues of the fact, some of which read like issues of law to myself. But these are the issues of fact that she purportedly is seeking to have addressed so that she can reach her determination as to whether or not the petitioner should succeed, and the petitioners, plural, should succeed in having this case and having him removed from the ballot. So I just wanted to share that thought with you. I have no idea what time this woman is coming in here. I like this. I like this. Can you do a poll? And then I like the chat. The poll is a reminder. It's a bump. People need I need reminders all the time. All the time. It's not a knock on anyone. I'll tell you this much. I'm going to admit to something on this very issue, and that is I frequently will forget to hit like when I come in. I just like, it's another first thing on my mind. So when you see a little reminder, you're like, oh yeah, that's true. I'm gonna give this guy a like. So yeah, and it's I find it to be a less grating reminder than me screaming, please hit like and subscribe. Please hit like and subscribe. So this is what is happening in court. I don't know I don't know where. I mean, the attorneys are there. She's calling for them to be there at 8 o'clock in the morning. And I will point out that Worcestershire sauce. It's not Worcester. It's not Worcester. It's Worcestershire sauce. New member of the following. The following is what people who join my channel are called. They're called followers because in the evening I host a show called The Following Program. So those who sign up are called followers. That's the $5 level. The $10 level, they're disciples. But the following is not a cult. A lot of people hear the name The Following and they think that this is a cult. I mean, it's definitely it's not a culty type of cult at all. Okay, and I think I've seen you. I know I've seen your name before. I think I've seen you as a member before, but whether or not you've been a member before, I'm just going to say to you, you should understand that it's not at all a culty type of cult. It's not at all a culty type of cult. It's like the least culty type of cult you've ever seen. And yeah, yesterday I had a whole question. Joe Brown, I used to be left in Trump meeting. Drink the Kool-Aid, join the cult. I have, you talk about like a lefty who watches me. I have someone who watched my stream yesterday who left. There's like, I don't know, on my stream that I did yesterday, there's like, I want to say roughly 50 comments, and like 38 of them are from one person. Nobody ever comments on my streams. Like, I mean, look, there are people who comment. I'm just saying my comment numbers are so small compared to like what I see on other channels. I think like in, considering the number of people just don't comment afterwards, which I think that's on me. I think I'm supposed to tell people, hey, if you're watching this, drop a comment below, let me know. And that's supposed to help engagement. That's the sort of thing that I suck at, which is part of the reason that my channel is like constantly on like a hamster on a wheel and trying to get anywhere. But so that part I accept blame for, because apparently that's on me. That's on me. There's really no one else who's going to be doing that unless someone like were to magically come into my room here, shove me aside, and say, "Hey, please leave a like and a comment," which seems unlikely. So, yeah, this one person who's very strongly on the left, very angry in a lot of the comments that I made, left like 38 comments. Like one comment after another. Like this woman must have been watching while, like commenting while she's watching, and like every 3 minutes just saw something else I said, which got her very upset. I'm trying to remember. It was something Rambo. I don't remember. Oh, you upgraded to disciple. You're so cool. Woohoo! Disciple of the cult. Yeah. Yeah, prophets. I had a high priest once. A high priest of the cult. A high priest of the we all hailed the high priest of the cult. All hail the high priest of the cult. I keep saying I'm going to create an intro, and that when I do, I'm going to actually acknowledge some of these people. But yeah, I don't know. I've been very, very bad about promoting my very non-culty cult. In high school, I was voted most likely to start a cult. So live the dream, baby. Live the dream. People can't appreciate just like how awesome it is to be the leader of a cult. Not that I am. I am not the leader of a cult. I'm not the leader of the following. I'm a follower just like you. I want to see if I can find here for you. He lies. It's a cult. One of us. Are they going to give us any sort of insight? Now, I also have another link here that I came up with. That's not through C-SPAN. I'm curious what this is. So while we're waiting, let's see what this is. This is the Colorado State link thing, and she's in room 209. This is her. Click here to view live stream. Oh my gosh, there's more to know. Denver courtroom 209. Oh, this is the courts. Ooh.
209 is now in session. Honorable Judge Sarah B. Wallace presiding.
Morning. Everyone may be seated.
Well, this is a good backup. No, this is Ben Sisney. All right, we're going in here. I'll figure that out later if need be.
Your Honor, I would just like to renew our motion to exclude.
And yeah, I know the audio sucks. This is as loud as I can get it. Let me see if I can upgrade it.
I would like to renew our motion to exclude the testimony of Mr. Maglioka under 702.
And that motion is denied on the basis of my previous written ruling. Anything from the secretary? Great. Let's call our next witness.
Your Honor, would you like entries of appearance first?
Yes, thank you.
For petitioners Jason Murray, Eric Olson, and Sean Grimsley, Martha Tierney, Mario Nicholas, and Nikhil Suss.
Thank you.
This whole thing is Nikhil Suss.
Your Honor, on behalf of President Trump, who is here today, myself, Scott Gessler, Jake Roth, and Sue Jennifer Shaw, and just now.
Well, not those prophets. 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 Prophets.
And Robert Kitzmiller on behalf
Thomas
of
Dietrich.
Republicans.
Thanks for commentary and coverage. Thank you for your support, my good friend. I haven't seen you in a while. I remember you.
And good morning, Your Honor. Michael Kotlarczyk on behalf of the Secretary of State, joined with Jennifer Sullivan from the Attorney General's office and Deputy Secretary of State Christopher Beal.
Great, thank you. And thank you, Mr. Murray.
Of course, petitioners call Professor Gerard Magliocca to the stand.
Professor Maglioka. You raise your right hand. Do you swear under the penalty of perjury to tell the truth, the whole truth, and nothing but the truth in this court?
I do.
Good morning, Professor. Could you introduce yourself, please?
Yes, I'm Gerard Magliocca,
How do you spell your last name?
Magliocca.
Where do you work?
I teach at the Indiana University.
Wow, those
Robert
years.
McKinney School of Law.
Now, you're here as an expert today. What topics are you here to testify about?
I'm here to give expert testimony on the history of Section 3 of the 14th Amendment.
How long have you been at Indiana University McKinney School of Law?
22 years.
And in those 22 years, has your scholarship had any particular focus?
Yes, I focus mainly on constitutional history.
Are you a member of any professional organizations related to constitutional history?
Yes, I'm a member of the Supreme Court Historical Society, the American Society of Legal Historians, and I'm on the board of editors of the Journal of American Constitution.
My God, I can't stop looking at this
Can you
Ferengi.
give us a general overview of what kinds of published works you have in the area of constitutional history?
Well, I've written 5 books and something in the neighborhood of 20 law review articles on various constitutional history subjects.
He has the lobes
Have you
for
written
law.
any books specifically about the 14th Amendment or its history?
Yes, about 10 years ago, I wrote a biography of Congressman John Bingham, who was the main drafter of Section 1 of the 14th Amendment as a member of the Joint Committee on Reconstruction.
Have you written any academic articles or journals related to the history of the 14th Amendment?
Yes, I have 4 articles that cover just different aspects of the history of Section 1, Section 2, and Section 3.
Do you have any other articles about 19th century history?
Well, yes, several. I mean, some of them cover the period of Jacksonian democracy. Some cover the period in the late 19th century, sort of around the populist period or the Gilded Age, and others of my books also focus on different aspects of those subjects.
You mentioned that you've written on the subject of Section 3 of the 14th Amendment. Tell us about that.
Yes, so in 2020, I drafted a paper on Section 3, and that paper was posted to the Social Science Research Network, which is the place where professors post their draft papers to share with the public, in December of 2020.
Was that later published?
Yes, that was published in 2021 in Constitutional Commentary, which is a peer-reviewed journal run out of the University of Minnesota.
Before you posted your article about
These are
Section
Wikipedia
3 on
pages, dude.
SSRN in December of 2020, give us a sense of the state of the existing scholarship on Section 3 of the 14th Amendment.
There really wasn't any.
So he's
How, if at all,
trying to
has
say,
that changed?
I'm the only
since
expert
then?
on this.
Well, it's changed quite a bit, especially in the last few months.
Oh, so
Have you
basically,
written
I'm an
any other
instant
articles
expert.
about Section 3?
Yes, I have a draft paper that
I wrote a paper 10 minutes ago.
in the Journal of Constitutional History, that's constitutional law, that is run out of the University of Pennsylvania. That was given as a talk at a symposium in January.
I wrote a paper 10 minutes ago, so
Can
I'm
you
the
tell
expert.
us whether any of your work on Section 3 has ever been cited by courts?
Yes, my original article was cited by the United States Court of Appeals for the Fourth Circuit, as well as a federal district court in Georgia.
Has your work on Section 3 ever been cited by any government agencies?
Yes, the Congressional Research
He
Service
wrote this
cited me
because of
analysis.
January 6th, all this stuff on
Have
Section
you ever
3.
given expert testimony on Section 3 of the 14th Amendment?
Yes, I have. I gave expert testimony on the history of the amendment in an administrative proceeding in Georgia that was addressing the eligibility of Representative Taylor Greene.
I want to pull up
Yeah, how'd that work out for you?
Petitioners Exhibit 162.
I testified about
is
the
this?
eligibility of Taylor Greene. Did you keep her out?
Is it current?
Yes.
I don't want to talk about every entry here, but just briefly, can you summarize your educational background for us?
Yes, I received my undergraduate degree from Stanford and my law degree from Yale.
If we go to the second page, just
Zach, what's happening? Sorry.
tell us briefly which of the books on your CV relate to 19th century history or constitutional history.
Who cares about that? We care about the 14th Amendment, the third section of the 14th Amendment, and what you know about that.
And is this entry here the biography you were referring to about John Bingham?
Yes, it is.
And if we go down to book chapters, law review articles, and essays,
This dude is
we see a few
compensating for
entries
a lifetime
related
of being
to
called Nosferatu
Section 3 of the 14th
by
Amendment
writing articles
those
about
the
how Trump should be kept
forthcoming
out because of the
article
14th Amendment.
and the previously published article that you mentioned earlier.
Yes.
And briefly on page 4, can you just highlight for us on this page of your CV some of the articles here that relate to 19th century history or the history of the 14th Amendment?
Sure. The one at the top is about Section
This is pretty much
2 of
who
the
he
14th
is.
Amendment. Then also the one, let's see, going down a little bit. Okay, why did the incorporation of the Bill of Rights fail in the late 19th century? Is it 19th century historical piece? And then also the one that's entitled Indians and Invaders, Citizenship Clause and Illegal Aliens focuses on.
I would completely object to this guy being an expert.
On the Citizenship Clause of Section 1.
You'll lose on it, but I would still
And,
object to it.
the paper on the legal tender cases, a new approach to congressional power.
None of this is about the 14th Amendment.
Supreme Court decisions on
None of this is
paper money.
And what are these papers about? Like how it's applied?
Until the 1880s.
No, you came up with that after
Constitutional false positive.
January- after
Amendment was about,
January 6th.
Constitutional development in the late 19th century, basically focusing on the 1890s. Cherokee removal
And yeah, I know I'm over talking him. Most testimony I don't over talk. When he's giving his CV though, that to me is a relatively inconsequential thing.
If we go to the next page of your CV, you have a list of recent professional activities. Do any of those relate to the history of the 14th Amendment?
Yes, so the podcast on Section 4, which I haven't written a whole article about that, but I did write about that in one piece of one article. I did a podcast with Eric Foner, who is basically America's leading historian on Reconstruction, earlier this year. And then the symposium piece is the one I mentioned earlier. That's my draft paper about another aspect of Section 3. And then there was a presentation about the Section 3 article last fall. And then I gave a talk last year about my biography of Bushrod Washington at John Marshall's house, which was rather fun.
He looks kind of psycho too. Those
And on the
eyes.
last page, I'm not going to highlight all of these, but did some of these also relate to Section 3 of the 14th Amendment?
Yes, I did a podcast with Professor Dan Hemmel in January of 2021 about Section 3. That was, of course, in the immediate aftermath of January 6th, 2021.
And what about this entry about John Bingham with Kurt Lash?
Yeah, so that was a podcast I did with Professor Lash for the National Constitution Center about John Bingham's career, and that was part of a series of events that commemorated the 150th anniversary of the ratification of the 14th Amendment in 2018.
When you're doing your historical scholarship on the 14th Amendment, what kinds
I have a
of
joke that I
sources
cannot
do you
say
consider?
out loud, so I'm just going to type in my locals
Well,
chat.
I mean, I'm trying to look at primary sources because that's where you try to get at the truth of what happened. So I'm always most interested in looking at those.
What are the types of primary sources that you would look at in your scholarship?
Well, they kind of run the gamut, but you could look at congressional debates and reports. You can look at presidential documents. You can look at judicial cases. You can look at contemporary newspapers, contemporary books. Basically, any kind of source that would be a sort of firsthand account of what occurred in a particular time.
I'm pulling up Petitioners Exhibit 144. What is this exhibit?
This is an index of the materials that I considered for my expert report.
And if we walk through this index, we see some cases, there's some citations to law review articles, some statutes, citations to congressional record, etc. Are those the sorts of materials that you would review in your historical scholarship outside the courtroom?
Yes, they are.
Tell us a bit about the historical methodology that you used in forming your opinions in this case.
Well, I mean, the first thing you want to do is make sure that the sources you're looking at are true and accurate. I mean, usually that's pretty straightforward because they are official government records. For example, there was an official compilation of presidential documents.
Oh my God.
in the
That's the
19th
joke of the day. That's pretty funny.
And I have a set in my office that I found in a antique shop one time. So I refer to that just to make sure that if I see a document online, that I can look it up to make sure it's a real document and there's not some error in transcription or something. For newspapers, it's a little more challenging. I mean, there are some sort of trustworthy databases of old newspapers. One's run by the Library of Congress. You can also cross-check newspapers because typically an article would be reprinted more than once, or at least the sort of substance of the article would be
Wow.
reprinted in other newspapers. You can try to make sure that whatever you're looking at is, in fact, an accurate rendition of whatever the article is discussing.
As a historian, what do you do if there's some kind of ambiguity or mismatch among different historical sources?
Well, look, the first thing you're looking at is kind of what is the context of the source you're looking at. Now, for example, in the case of the 14th Amendment, you would be more interested in what supporters of the amendment had to say than you would be about what an opponent of the amendment would have said. In the same way that if you were looking at a judicial opinion, you'd be more interested in what the court said rather than what any dissenting opinions said to understand what the opinion was about. Also, you would look at who the speaker or author was. Now, some people were just more authoritative than others in their exposition of the 14th Amendment. And at the top of the list, or near the top, would be John Bingham, and not just because I wrote a book about him, but because he was centrally involved in all elements of the 14th Amendment's proposal and ratification and implementation. And this has been recognized by the Supreme Court many times and by scholars many times.
Can you tell us whether or not the historical methodology that you've just laid out was the method that you used in forming and presenting your opinions in this case?
It was.
At this time, petitioners move to admit Professor Magliocca as an expert in the history of
Objection.
Section 3 of the 14th Amendment.
Objection.
Your Honor, we have no objection to.
Really?
Magliocca's expertise. We renew and endorse the 702 motion.
Professor Magliocca will be admitted as an expert in the history of Section 3 and 14 of the 14th Amendment.
Thank you, Your Honor. Let's start by setting the stage for the adoption of Section 3. What does the historical record tell us about why Section 3 was put into the 14th Amendment in the first place?
Well, the main thing that prompted Section 3 was that they wanted to keep officials who had left.
I tried finding this when I saw your chat.
From returning to office unless they showed that they deserved a second chance to return to office. So basically, there were elections held throughout the South in 1865 after the war ended, and many of the same people who had been in office before the war and had left to join the Confederacy were returned to office, and some of them showed up to the new Congress and essentially said, okay, we're here to take our seats now, as if nothing had happened. And congressional Republicans were very upset at this idea. They felt that this was wrong. And so there was a proposal by the Joint Committee on Reconstruction to do something to exclude people like that from positions of authority unless they demonstrated some repentance or deserved forgiveness.
Does the historical record tell us anything about whether that was intended as punishment for insurrectionists?
Yes, I mean, it was not intended as punishment. There was a number of senators discussed the fact that this was simply adding another qualification to office because of the events that had occurred.
What does the historical record tell us about the role that the oath plays in Section 3?
So the oath plays a central role, not just in the text, but in the rationale for Section 3, in two respects. I mean, the first is, it was a way of limiting the scope of the provision. They didn't want to disqualify all former Confederates from office or from serving. They wanted to focus that on the people they thought were most responsible for secession and the Civil War. And the oath was a way to do that. Now, secondly, senators said, if you had sworn an oath to support the Constitution and you had broken it by engaging in insurrection.
That's essentially, but that's not precisely what they say.
It was a kind of moral perjury, that was a term that some people use, that you had engaged in, and you were just untrustworthy to hold office again unless you demonstrated some reason why you should be allowed a second chance.
What, if anything, does the historical record tell us about whether Section 3 was limited to the events of the Civil War or not?
It was not limited to the events of the Civil War, and we know that because first the language was general, which is referred to insurrection or rebellion, And secondly, there were senators in the debate that made pointedly clear that they thought it also should apply to any future insurrection that might occur.
When did the 14th Amendment
language?
get ratified?
1868.
In the years after its ratification, walk us through some of the ways that Section 3 got enforced to exclude from office those who had been engaged in insurrection or rebellion in violation of their oath.
Okay, so this happened in different forms. In some states that were under martial law, the Union Army did the enforcing. In southern states that were no longer under martial law, state officials and state courts did the enforcing. Individual houses of Congress also
Really?
sometimes did the enforcing if someone
At
was
what
a member
stage?
elect, and then there was a question raised about whether they could be seated because of some involvement with the Confederacy. And then the individual House of Congress, the House of the Senate would have to decide if the person could be seated or not. And then finally, in 1870, Congress created a federal civil action to enforce Section 3 by allowing U.S. attorneys to bring a writ of quo warranto to oust officials who were in office illegally because of Section 3.
You mentioned state courts enforcing Section 3. Tell us a little bit more about that history.
Yeah, so in 1869, there were cases in North Carolina and Louisiana that addressed enforcement of Section 3 of the 14th Amendment against state officials pursuant to state enforcement mechanisms. So in North Carolina, there were 2 officials who were removed from office as ineligible, and in Louisiana, they didn't remove the person because of a procedural reason, but they said that it could have been had the procedural posture been correct.
Were those cases in North Carolina and Louisiana before or after the enactment of federal implementing legislation in 1870?
They were before, they were in 1869.
Tell us a bit about the history of amnesty under Section 3 and Congress's power to remove the disability by a 2/3 vote.
Right, so as soon as the 14th Amendment was ratified, applications poured in from people who were disqualified seeking a waiver. Basically, you would apply to your member of Congress, and then what Congress did initially was pass a series of measures that would simply give amnesty to people by name, right? There would be a list of names, all of these people get amnesty if you could get a 2/3 vote of each house to pass the legislation. After a couple of years, Congress decided to create a more general amnesty that did not involve individual names, and that was enacted in 1872 and gave amnesty to nearly all of the people covered by Section 3, except for a few hundred who were sort of considered the worst of the worst, including Jefferson Davis, the former president of the Confederacy.
And what does that history of amnesty tell you about the historical understanding of whether congressional legislation was needed to enforce the disability of Section 3?
Well, it tells me that people didn't think it was needed. Now, that goes along 2 dimensions. First, the people who were applying for amnesty must have thought that they needed it right away. And why did they think that? Probably
No, that's
because
ridiculous inclusion.
ratified, and states were in
I just didn't want to have to deal with a legal hassle later.
Secondly, Congress granted amnesty to these individuals in some cases before any enforcement legislation was enacted. And in a sense, they were removing a disability that existed because the 14th Amendment had been ratified. They couldn't remove something that didn't exist.
I'm going to pull up the language of Section 3, and I want to first highlight the phrase insurrection. Have you studied the historical meaning that the word insurrection would have had at the time of ratification of the 14th Amendment?
Yes, I have.
What did insurrection mean at that time?
Well,
Anyone who participated in the Civil War.
An insurrection was any public use of force or threat of force by a group of people to hinder or prevent the execution of the law.
Where do
What
you
were
come
some
up
of
with
the
that?
historical sources that you
Where do you
looked
have
at?
that?
that
Where do you have that?
informed your
Where's that?
understanding of insurrection as a public
To hinder the
use
law
of
or to
force
overthrow the country?
or threat of force to prevent execution
How do you
of
have
the law.
hinder? That's
Well, I
ridiculous.
looked at historical examples of insurrections that occurred before the Civil War, as informed by some presidential documents about them. I looked at dictionaries, I looked at judicial decisions, and I looked at an authoritative treatment of the law of war that was issued during the Civil War.
You mentioned historical examples. Tell us a little bit more about what historical examples informed the understanding of insurrection during Reconstruction.
Sure. Well, there were two notable insurrections early on in American history. One was the Whiskey Insurrection, which is also known as the Whiskey Rebellion. And that happened in 1794 in Pennsylvania. It was a tax protest by farmers who were angry at a new federal tax on distilleries that had been put in as part of Alexander Hamilton's financial scheme for the federal government. And during that time, armed farmers basically attacked federal tax collectors who tried to collect the tax, or used intimidation to prevent them from doing so. Eventually, President Washington called out the militia to sort of restore the legal authority of the government on tax collection. And a few people were prosecuted, but President Washington pardoned them all.
How many roughly armed farmers were involved in the Whiskey Insurrection?
In the hundreds.
You mentioned that there was another example you looked at. Tell us about that.
Yes, the second example was called Fry's insurrection. That was in 1799. That was in a different part of Pennsylvania. There was a different group of farmers who were upset about a different tax. This time it was a federal property tax. And they used intimidation to prevent the tax assessors from the federal government from coming in and do the property assessments that would have been necessary to collect the tax.
And what was the scale of the violence involved in Fry's insurrection?
Uncle
Well,
Fester.
there was no actual violence. There's no record of anybody being killed.
It would be really cool if he put a light bulb in his
And
mouth.
again, you were talking about hundreds of armed farmers who were sort of behind the sort of resistance to this tax.
If there was no actual violence, in what sense was it understood to be an insurrection?
Well, it involved a threat of violence. That is, there was violent intimidation of the federal tax officials. And that did the trick, at least from the point of view of the farmers, for some period of time.
What relevance did the Whiskey Insurrection and Fry's insurrection have to the historical understanding of the meaning of insurrection during Reconstruction?
Well, these were well-known examples. I mean, probably the Whiskey Insurrection was a little better known because
I
it
knew
was
what you meant.
referred to in the 39th Congress. You can find books written about the Whiskey Insurrection in the run-up to the Civil War, and also one of the leading cases on sort of discussing insurrection arose out of Fry's insurrection. It was a case from 1800, so all of this would have been background that people would have been familiar with at the time.
These weren't obscure examples.
No, not at all.
I'm sorry, Professor, so when you say that it informs what an insurrection was at a time, is that because like case law called them insurrections or?
Well, yes, in part. The case of Fry's, for example, which arose out of Fry's insurrection, described it that way, as did President Adams' pardon of the individuals who were involved.
And you've already touched on this, but did either of these examples rise to the level of a full-scale war or rebellion?
No.
You also mentioned that you looked at some dictionary definitions. Tell us what we're looking at here.
This is Webster's Dictionary from 1828.
This is on page 785 of your appendix. How did Webster's dictionary define insurrection at that time?
Webster's defined it as a rising against civil or political authority, the open and active opposition of a number of persons to the execution of law in a city or state.
And did Webster say anything about any difference between insurrection on the one hand and rebellion on the other?
Yes, it said that a rebellion was basically an attempt to overthrow the government or create a new government. People to some degree use those terms interchangeably because, as I said, the Whiskey Insurrection is sometimes called the Whiskey Rebellion, but this definition defined them more stark, differentiated more stark.
Was this the only example of a dictionary definition that you found informative?
No.
I want to pull up page 747 of your appendix. What is this?
This is a dictionary from 1848 by the Reverend John Bow, who was a noted English lexicographer.
Why did you look there?
Well, because it is he was a noted person. I mean, not as famous as Noah Webster, obviously, but it had a definition of insurrection within it.
How did the definition in this dictionary compare to what we just looked at in Webster's dictionary?
It is essentially identical.
You also mentioned that you looked at cases defining insurrection. Tell us first a bit about how those cases came up.
Right, so prior to 1862, there was no crime of insurrection. So the only time that cases discussed insurrection came in treason cases when judges were instructing juries, giving them a charge on treason, and invariably they would discuss what an insurrection was in those charges.
If we go to page 750 of your appendix, is this one such charge?
Yes.
And tell us the circumstances of this charge.
Okay, so this is a charge to a grand jury in the United States Circuit Court in Missouri in 1861. The way things worked then, Supreme Court justices would participate in trials to some extent, and so this grand jury charge was presided over by John Catron, who was an associate justice of the court at that time.
If we go to page 752, I apologize, sometimes these historical sources are a little bit hard to read, but can you tell us how Justice Catron defined insurrection?
Yes, he said that conspiracy and the insurrection connected with it must be to affect something of a public nature concerning the United States. And that included overthrowing the government or to nullify and totally hinder the execution of some U.S. law or the U.S. Constitution or some part thereof, or to compel its abrogation, repeal, modification.
So this is what one guy said.
Resort to violence.
And how does that inform your opinion here?
Well, I mean,
It
that
dictates
is
my opinion.
An authoritative statement of law in 1861, close to the time when the 14th Amendment was ratified. And it is consistent with the...
So this is what one judge said in 1861. Clearly, that's what the Constitution... That's what the Constitution means.
The examples of the Whiskey insurrection and Fries' insurrection, where there was no attempt to overthrow the government, there was an attempt instead to resist the execution of law.
Was this instruction by Justice Catron an isolated example in the case law?
No.
Tell us a bit more about that.
Well, there are other treason cases from before the Civil War that had very similar language. So one I mentioned earlier was a case called Case of Fries, which was about Fries' insurrection, and then another called United States versus Hanway from the 1850s.
How did the charges in Case of Fries and Hanway compare to Justice Catron's charge here?
They're essentially identical.
You said you also looked at sources related to the laws of war.
How many people have been charged with insurrection?
553 of your appendix.
How many
Tell us what we're looking
J6ers
at
were
here.
charged with
So
insurrection?
this is the legal code that was issued to the Union Army during the Civil War.
And why did you look at this source by Francis Lieber?
Yes, well, a couple of reasons. First is it was the authoritative sort of law of war that applied during the Civil War. And secondly, Francis Lieber was probably the leading legal scholar of his day, and so he's a particularly authoritative author or speaker on these kinds of questions.
On page 594 of your appendix, walk us through what Francis Lieber said constituted an insurrection.
He said that insurrection is the rising of people in arms against their government or a portion of it, or against one or more of its laws.
And how, if at all, in this source, did insurrection contrast to civil war or rebellion?
Well, Lieber described a rebellion as simply a very large insurrection, although he then went on to say that often it involved an attempt to overthrow the government or to set up a separate government.
And again, how does this discussion by Francis Lieber inform your opinion as to the understanding of insurrection during Reconstruction?
Well, it's consistent with all the other sources that I looked at.
Can you tell us whether or not you saw any serious disagreement during Reconstruction about the meaning of the phrase insurrection?
No, I did not.
How have today's historical scholars addressed the definition of insurrection?
Well, of the ones who have addressed it recently, they have been in agreement basically with the opinion that I'm offering and these sources. That you
Basically.
see, in particular, the draft paper by Professor William Bode and Professor Michael Stokes-Paulsen, and the work, again, a draft paper by Professor Mark Raber at the University of Maryland.
If we go back to the language of Section 3, I want to now turn our attention to the phrase insurrection or rebellion against the same. How, if at all, does the language against the same affect your opinion as to the historical understanding of Section 3?
Well, that the language limits the definition of an insurrection for Section 3 purposes to one that is against the Constitution of the United States.
And so how does that limit or change the definition of insurrection?
Well, it eliminates a certain class of insurrections from things that would be considered for purposes of Section 3. So the most obvious example would be an insurrection against state or local law. That would not be a Section 3 insurrection because it does not involve the Constitution of the United States.
Does the historical record tell us anything about why Section 3 would be limited to a particular type of insurrections, namely those against the Constitution?
Okay, well, one is, again, they were concerned to limit the scope of the provision, right? And this is a way of doing that. And then second, there's a thought that since the oath was central to both sort of the limitation and the rationale, the oath that you take is to the Constitution of the United States. It's not to the United States generally. And so it makes sense to think that the insurrection we're concerned about, or rebellion, would be one against the Constitution that you swore an oath to support.
I want to draw our attention now to the language shall have engaged in insurrection or rebellion. Does the historical evidence shed light on what it means to have engaged in insurrection, or how that would have been understood historically?
Yes, I mean, during Reconstruction, engage in insurrection was understood broadly to include any voluntary act in furtherance of an insurrection against the Constitution,
Of course.
including words of incitement.
Of course,
What
including words and
sorts of historical sources did you look at in forming that opinion?
Well, I looked at judicial decisions. I looked at opinions of the United States Attorney General. Those were sort of the two leading sources that I looked at.
I want to pull up page
what-
788
and what there told you that.
of your appendix. Tell us what we're looking at here.
This is an opinion by the United States Attorney General in 1867 interpreting the Military Reconstruction Acts of Congress.
Okay, and what's the historical significance of this opinion of the U.S. Attorney General interpreting the Reconstruction Acts?
Okay, this will take a minute to explain. So in 1867, Congress passed a series of measures that placed most of the former Confederacy under martial law. And in doing so, Congress ordered that these states hold new elections for conventions that would write new state constitutions and would ratify the 14th Amendment. Now, as part of the direction as to how these elections were to be run, Congress said that people who would be disqualified from office by the language of Section 3 of the 14th Amendment should not be allowed to vote in the elections for these new conventions. And the Union Army was tasked with enforcing this provision.
So just to back us up a little bit, this is May of 1867. Was that after Congress had submitted the 14th Amendment for ratification?
Yes, it was in the period between the submission of the amendment to the states and its ratification. So the statute refers to the proposed Section 3 of the 14th Amendment.
And to be clear, how did the language of the Reconstruction Acts compare to the language of the proposed constitutional amendment in Section 3?
It was identical.
Did this opinion of the U.S. Attorney General have any kind of legal effect?
Yes, it did. The opinion was approved by the cabinet. We have the cabinet minutes on that. And then was the basis for instructions that were issued to the Union Army commanders in the former Confederacy as to how they were to implement Congress's directive on these elections.
What form did the instructions to the Union Army take in terms of implementing the opinion of the Attorney General on the Reconstruction Act?
Basically, there were instructions issued by the Secretary of War. Also, Ulysses S. Grant was involved because he was the general of the armies at the time.
How is that relevant?
Can you tell us whether or not those instructions included the language of this opinion?
They did.
So how would you characterize the historical significance of these opinions by Andrew Johnson's Attorney General?
Well, they are an authoritative interpretation by the Attorney General of the United States
No.
on the language that ended up being ratified in Section 3 of the 14th Amendment.
Who was the Attorney General at that time?
Stanbury.
I want to direct our attention to page 800
But that's not
of
anything to do
your
with
appendix.
incitement.
Walk us through what Attorney General Stanbury said about what it means to have engaged in insurrection.
Well, he described it as some direct, overt act done with the intent to further the rebellion. And then later he said that the act had to be voluntary because there was some concern about people who were drafted into the Confederacy that they not come under the disqualification because they had not acted voluntarily.
Act is not words.
So basically, a direct, overt act done with intent to further the rebellion.
Act is not words. His
There's a
conclusion here
discussion
is
here of mere acts
bizarre.
of common humanity and charity can't be
because words
considered
have
as
much
participating
broader
in the
protection
rebellion,
than action.
or
That's the
forced
whole thing about freedom of speech.
contributions can't be
You're
seen
interpreting
as
overt act
participation, correct?
as being speech.
Did
as
the opinion
incorporating
of the
speech.
Attorney General identify
The First Amendment
any
implies
other
otherwise.
conduct in furtherance of insurrection or rebellion that would be considered outside the scope of Section 3?
No.
No,
What
because
does this source tell you about whether or not someone would have needed to have
Doesn't mean
taken up
Orange Man is bad.
arms in order to
It has
have been
to be kept out.
understood to have engaged in insurrection at this time?
It was not required.
no, of course not.
Let's go to page 804 of your appendix. Tell us what we're looking at here.
Well, this is a second opinion that the Attorney General issued because, remember, the Army had never organized an election before, so that the Union Army commanders requested additional guidance from the Attorney General as to how to do this. So a second opinion was issued.
Does this second opinion have any historical significance?
Yes, again, it was approved and used as a basis for instructions to the Union Army commanders.
If we go to page 815, walk us through what this second opinion of the Attorney General tells us about what it meant to have engaged in insurrection.
Well, again, here it says that it must be an overt and voluntary act done with the intent of aiding or furthering the common unlawful purpose, namely the insurrection. And then that voluntary contributions, even such indirect contributions as arise from a loan of money or the purchase of bonds, would count for disqualification.
And so again, what does that tell us about whether or not Section 3 was understood to apply only to those who took up arms against the Union?
It did not apply only to those who took up arms.
Later in that page, what did Attorney General Stanbury say about speech?
Well, he said that disloyal sentiments, opinions, or sympathies would not disqualify, but when a person has, by speech or by writing, incited others to engage in rebellion, he must come under the disqualification.
And what's incitement? What is
Now,
incitement?
we've seen this discussion in the Attorney General's opinion about a voluntary act in furtherance of the rebellion. Tell us how early judicial cases compared to this discussion in the Attorney General's opinion.
They are consistent.
If we go to page 203 of your appendix, what is this case?
This is Worthy versus Barrett, one of the North Carolina cases that I referred to earlier,
And when was this case decided?
1869.
On the second page, what does the Worthy Court say about what constitutes engaging in rebellion?
Well, a voluntary act by personal service or by contributions other than charitable of anything that was useful or necessary.
How did that compare to what we just looked at from Attorney General Scamberry?
It's essentially the same.
Were there any other cases addressing this language at this time?
Yes, there was a federal case in North Carolina in 1871, United States versus Powell, that again said that a voluntary act in furtherance of insurrection or rebellion was the definition of engaged in insurrection.
Were there any cases at this time that disagreed with Attorney General Stanberry's opinion that words of incitement were enough to have engaged in insurrection?
Not that I'm aware of, no.
In your report, you also discuss some pre-Civil War cases on the law of treason. Why did you look at those cases?
Well, as I mentioned earlier, the only time that judges discussed insurrection before the Civil War came in treason cases, so naturally I wanted to look at those.
Do those cases, those treason cases from before the Civil War,
Doesn't that completely
shed
refute
any
everything you said
light
about insurrection until
on
now?
this question of whether or not someone needed to have personally taken up arms in order to have levied war against the government or engaged in insurrection?
Yes, they make clear that you do not need to take up arms to be engaged in levying war. You could do so by encouraging or instigating an insurrection.
And did those cases specifically address this issue of instigation or incitement?
Yes, they do.
And you touched on this a minute ago, but walk us through kind of what those cases said about incitement.
Well, I mean, basically, they said that just because you had not been on the scene of the violent event, or that you had sort of not taken up arms, that didn't matter. That what mattered was basically you could be engaged in an overt act supporting treason if you instigated, incited, encouraged that activity.
During Reconstruction and during the Civil War, did Congress ever address this issue of disqualifying insurrectionists?
Yes, so as I mentioned earlier, if a member-elect showed up to the House of Representatives or the Senate, there could be a challenge about whether that person was involved in the Confederacy, and then each House of Congress would have to assess whether they're involved and disqualified.
Sorry, wrong button.
Let's turn to page 463 of your appendix. What is this historical source?
This is Hines Precedents of the House of Representatives, which is an authoritative source of decisions by individual houses of Congress running through the 18th and 19th centuries.
Why did you look at Hines precedents?
Well, this is where you would look for precedents from individual houses of Congress as opposed to, say, legislation or judicial precedents.
Tell us a bit about the case of John Young Brown.
Yes, so John Young Brown was a member-elect to the House of Representatives from Kentucky, and when he arrived in 1868, he was challenged on the ground that he had given aid to the Confederacy.
Let's look at page 465 of your appendix. And I want to pull up some language here. What are we looking at here?
They practiced this.
This is essentially a letter
3
to the
times.
editor that Mr. Brown
They probably
wrote
had him write the
during
questions.
Civil War, in which he advocated
Chances are very high that he wrote the
against
questions.
Union troops that might enter Kentucky.
And was there any argument in the case of John Young Brown that he had done anything to aid the rebellion other than this letter to the editor?
No, this was all that he was accused of doing.
How did Congress decide the case of John Young Brown?
They did not seek Mr. Brown.
On what basis?
That he had been involved with the Confederacy.
Not involved.
Now, you said this case was in 1867, correct?
1868.
1868?
He had
Was
taken
that
up
before
arms.
or after Section 3 had been ratified?
It was a little bit before Section 3 was ratified, so it was not a Section 3 enforcement, strictly speaking.
So on what basis did Congress say that Mr. Brown was disqualified?
Well, they
Nothing
the
having to do with
House
this
has broad
case,
power
but-
to disqualify or refuse to seat members-elect, especially in that era. And so basically they said that he had given aid to the Confederacy through this editorial.
If the case of Mr. Brown was not a case applying Section 3 itself, why did you look at it in informing your understanding as to the scope of Section 3?
Well, because this decision was taken in the year that the 14th Amendment was ratified, and it concerned the kind of conduct that would be considered disqualifying. So it seemed like informative as an example for what people might have been thinking about when the provision was subject to ratification.
And how much latinum were
Did
you
you look at
paid
any
for
other
your testimony?
congressional cases of disqualification or exclusion?
Yes, there was one other case in 1867 of Philip Thomas. Mr. Thomas was a senator-elect from Maryland, and he had given $100 to his son before his son went on
Nope,
to
they didn't address that part
the
yet.
Army, and he was challenged on the grounds that he had given aid to the
Although
Confederacy.
he tried playing in that's anyone who took the oath
Have you
of
done
office.
anything other than give $100 to his son when his son was leaving to join the Confederate Army?
No,
And that was considered a
How
violation.
did
of your
Congress
oath.
address the case of Philip Thomas?
they did not seek Mr. Thomas,
On what basis?
that he had given aid to the Confederacy that was disqualified.
Same question as with Mr. Brown. Was that a Section 3 case?
No, it was not, because it came in 1867, a year before the 14th Amendment was ratified.
And did you still consider that to be relevant in understanding the historical backdrop to Section 3?
Yes,
Look
for
at the
reasons
banner.
I just identified.
I always put in the
That
banner who's
while Section
testifying
3 was pending before the states and concerned
and what their role
whether
is.
conduct would be considered disqualifying from office.
You've mentioned historical
Those who hit like and
sources
subscribe.
discussing a voluntary act in support of insurrection by words or deeds. Did the issue of inaction
That thing actually
ever come
matters.
up? Were there any cases where an individual was
It's
charged
been
for having
qualified,
abdicated
so.
a duty to protect the Constitution?
No,
So does the historical evidence kind of tell us anything one way or another about whether they saw any kind of inaction as potentially being covered by Section 3?
no.
If we step back and look at all the historical sources that you've just discussed, what do those sources tell us about whether or not an individual is disqualified or was understood to be such at the time without having taken up arms against the government himself or herself?
Well, the answer is you could be disqualified without having taken up arms against the government in the period of the Civil War.
Obviously.
I want to move now to a discussion of offices and officers. Set the table for us a little bit about how those terms come up in Section 3.
Sure, well, Section 3 says that no person shall hold any office, civil or military, under the United States or under any state, if they have taken an oath as an officer of the United States, among other things, to support the Constitution of the United States and then have engaged in insurrection against the same.
So to be clear, first you have to have taken an oath as a qualifying official or officer of the United States and then engaged in insurrection.
Correct.
And if you've done that, if you've taken an oath as an
You can't be a
officer and
senator.
engaged in insurrection, then what kinds of offices or positions are you disqualified from at that point?
Right, that's correct. So the first portion describes the offices and the second portion describes the officers.
Have you looked at historical evidence bearing on the question of whether the office of the presidency was understood to be an office under the United States such that a disqualified individual could
Why
not
would
take
they
that
say
office?
elector of president,
And,
but
and
not
what is
president?
your opinion on that question?
My opinion is that during Reconstruction, the presidency was considered an office under the United States for purposes of.
Ah!
And have you looked at historical evidence addressing
They just
whether
didn't
or
put
not
the
the
word
president
president in.
during
They put
Reconstruction
senator,
was
representative, they put
considered
stupid
as an
electors,
officer
but not
of the
president.
United States?
I have.
And what is that opinion?
My opinion is that during Reconstruction, the president was considered an officer of the United States for purposes of Section 3.
In addressing the meaning of officer and office, what kinds of historical evidence did you look at?
So I looked at congressional.
This is
debates and
asinine.
reports. I looked at presidential documents.
This is asinine.
Opinions of the United States Attorney General. I looked at judicial decisions.
Officer means like an off, like a.
Newspapers, organizations.
It
Did
means a
historical
marshal.
sources at this time define, in the context of Section 3, what it meant to be an officer of the
It just
United
couldn't
States?
list all the officers.
Yes, they did.
And what did they say you had to do in order to be an officer of the United States?
Well, the main thing was that you had to have taken an oath to support the Constitution. That again, the oath was central to.
So then why
protecting
list
purpose
senator and member of the
was
House?
also considered pivotal
Just say
to the
officers.
question of whether you were an officer or not.
If we go back,
Why
to the
why list
North
both senator
Carolina
and member of the
Supreme
House?
Court's
Say anyone who
decision
took
in
an oath.
Worthy, was this one of the
Idiocy.
cases on this issue that you were
This guy
mentioning
is
earlier?
gaslighting now. Now he's gaslighting. At this
What did the
point.
Worthy Court's decision tell us about who is an officer?
Well, the court said that it did not know how better to draw the distinction between an officer and a mere placeman, say, an employee, than by making his oath the test.
At a lower level.
And then went on to say that every officer
At a
is
lower
required
level
to take
than
oath of
member of the
office to
House.
support the Constitution of the state and of the United States.
So stupid.
Did Attorney General Stanberry ever address this issue as well?
Yes, he did in one of his opinions that we looked at earlier.
This is a
If
joke.
we go back to the first opinion of the Attorney
This
General
dude's a joke.
on page
And not
797
just because his
of your
ears
appendix,
make him look
walk
like
us
he was paid
through
in
what
Latin instead of
Stanberry
cash.
said about officer of the United States under the language of Section 3.
Well, he said that the term is to be used in its most general sense and without any qualification, and that the oath was
Unless they're excluded.
to determining whether someone was an officer or not.
And how did Attorney General Stanberry's opinion that officer is used without any qualification relate to your opinion as to whether the presidency was understood to be covered at this time?
Well, there was no qualification for the President of the United States.
I want to ask you briefly about an argument that's been made in this case. That the president's oath under Article 2 to preserve, protect, and defend the Constitution of the United States is not, for purposes of Section 3, an oath to support the Constitution of the United States. Are you familiar with that line of argument?
Yes, I am.
Have you seen any historical evidence that bears on the question of whether the president's oath to defend the Constitution would have been understood to fall under Section 3?
I have.
I'm pulling up page 869 of your appendix, and I apologize, this is another one of those hard to read historical sources, but what are we looking at here?
This is a grand jury charge that was issued by a federal circuit judge in Tennessee in 1870, and it was reprinted in newspapers.
Well, why are we looking at a newspaper here?
Well, because in those days, grand jury charges were often reprinted in newspapers as a kind of exercise in public education, as well as just to tell people what was going on in the courts.
And who originally identified this historical source?
I did.
Okay. What did this charge tell us about oaths in Section 3?
Well, Judge Emmons said, the oath which shall have been taken need not be in the precise words of the amendment, quote, to support the Constitution of the United States. He went on to say that there were slight differences in the forms of the oaths that people took, but the important thing is whether they include, substantially, even if not literally, an obligation to the federal power, and that the jury was not to consider the argument that, in fact, the wording of the oath did not include the word support.
How does that relate to your opinion that the oath that the president swears to defend the Constitution is covered by Section 3?
It leads me to the conclusion that it is covered because the difference in wording is irrelevant.
They just happen to choose different words.
Did you also consider
Some judge in
any
Tennessee in
presidential
1870 said
proclamations
they happen to have different
in
words, but I
addressing
think
whether
they
the
mean the same
president was
thing.
considered to be an officer of the United States at this time?
I did.
And tell us a bit about those proclamations.
Well, these are proclamations that were issued by President Andrew Johnson, who was the president at the time that the 14th Amendment was ratified, in which he explained how he had the authority to create provisional governments in the Confederacy following the surrender to Grant.
If we look at page 442 of your appendix, is this one of those proclamations?
Yes, it is.
Tell us a bit about the context here.
Yes, well, the president is issuing, in effect, an executive order, they call it a proclamation, where he's establishing a government in one of the former Confederate states, and he justifies that on the grounds, in part, that he is the chief civil executive officer of the United States.
And remind us what year this was.
This is 1865.
Before, shortly before Section 3 of the 14th Amendment was adopted.
Yes.
Was this an isolated example of President Andrew Johnson?
This is 3 years
No,
before
he
it was
issued
adopted.
the same proclamation for different states throughout the Confederacy, and these proclamations were widely reprinted in newspapers at the time because they were setting forth the terms of the governments that were to govern in several states.
So now we're going to get our American law based on laws
Was
that were passed
Andrew
in the Confederacy.
Johnson the only president in the 19th century to refer to himself as an officer of the United States?
No, President John Tyler in the 1840s referred to himself as
They identified as an officer. Ergo, they were
and President
officers.
James Buchanan, who was Lincoln's predecessor, referred to himself as the chief executive officer under the Constitution.
But that's not what
In your
Congress
report, you also
necessarily
talk about
thought back
examples
then.
of how this issue came up in Congress.
Some
Tell us a bit about
individual-
that.
Oh, here we
Yes,
go.
Well, there were references to the president as either the executive officer of the United States or an executive officer of the United States in Congress. Multiple
Why doesn't it say
times,
executive
whether
officer?
Congress Either that proposed the 14th Amendment or the one that oversaw its ratification.
I want to look at page 488 of your appendix, an excerpt from the Congressional Globe. What are we looking at here?
This is a speech by John Bingham in 1868 in which he describes the president as the executive officer of the United States.
And remind us what John Bingham's role was in the adoption of the 14th Amendment.
Well, he was the principal drafter of Section 1 of the amendment.
This dude is tying himself in so many pretzels to try and stretch this
Which was
statute.
the pivotal committee that essentially assembled the proposal of the 14th Amendment more generally.
Tell us about some of the other contexts in which this issue of the president as
Cherry
an
pick
officer
this
of the
case
United
here,
States
that
came
case
up
here, this
at this
case
time.
here, and tie them all together into
Also
this is what the
addressed in
14th Amendment
President
means.
Johnson's impeachment trial, which occurred in 1868, shortly after this speech that Bingham gave, in which the president's own lawyer described him as an executive officer of the United States.
Executive office.
Was that an isolated reference in Congress at the time?
No, there were many other references to the president as different formulations, whether.
How hard would it have been
executive
to actually
officer
write the
of the
words, no
United States,
president,
executive officer of the
vice
United
president,
States, when he's near executive
senator?
officer of the United States,
How hard would that have been?
various members of Congress, including Bingham on at least one other occasion.
Let's look at page 811 of your appendix. This is from the second opinion of Stanberry on the Reconstruction Act. And what did he say on that issue?
Well, he said that the president, who was his boss, is simply an executive officer.
Did anyone at the time specifically address the question of whether Section 3 covered the office of the president?
Yes.
How did that come up?
That came up during the Senate debate on the Section 3 language.
I'm pulling up page 477 of your appendix, excerpts from the Congressional Globe from that time. Walk us through how that issue came up in the debate about Section 3.
So a question was posed as to why the president or the vice president was not specifically mentioned among the offices listed in Section 3. And Senator Loudmore of Maine, who was a supporter of the 14th Amendment, said, well, let me call the senator's attention to the words, hold any office, civil or military, under the United States. And then the response to that was, in effect, oh, yes, I'm sorry about that. Never mind.
Then why
when I
list
first
senator?
saw this excerpt in 2020 when I was researching the original article, it was very exciting because you rarely get such a clear statement of legislative history, right? Normally legislative history is about things that you're not particularly interested in, or they're more vague in their phrasing. This is about as specific as you can get.
Why
Were you the one
list
who dug this up?
senator then? He went
Did
and dug it up.
anyone come back later in the debate and say, actually, you were wrong, we are excluding the presidency from Section 3?
No.
They
Talk
also
to us a
said-
bit about how Jefferson
in the
Davis
debate, they said no
came
Trump
up in the
or
debate
officer.
around Section 3.
Well, there was a consensus at the time that Jefferson Davis was ineligible to be president because of Section 3. And when Congress considered granting amnesty to individuals, an objection to granting amnesty to everyone was that, well, that would give Jefferson Davis amnesty, and that meant that he could then be president of the United States, which people thought was just unacceptable.
And when specifically did that issue of kind of amnesty, including Jefferson Davis, come up in these debates?
Well, it came up more, I mean, it was discussed a little bit during the time that the 14th Amendment was under ratification pending, but it really came up more when the debate on amnesty heated up in the 1870s, around the time of the General Amnesty Act in 1872, and then again in a debate in 1876 when they were thinking about giving amnesty to the remaining few hundreds of people who had not been given amnesty in 1872.
In the discussions about amnesty that might allow Jefferson Davis to become the president again, describe kind of the tone of
They were
the
specifically
supporters of
worried about a
Section 3
president,
at
but
that
did not
prospect.
specifically word a president other than making a vague reference to officers.
Could be eligible
Okay.
to be president of the United States, and they insisted that the only way that would happen is if he were given amnesty.
Can you tell us whether the historical purpose that you've identified behind Section 3 tells us anything about whether or not the president was understood to be excluded?
Well, yes, in the sense that it would have been odd to say that people who had broken their oath to the Constitution by engaging in insurrection were ineligible to every office in the land except the highest one.
Did the debates ever talk about kind of high office versus sort of lower level officials in the context of Section 3?
Yes, there were references in the Senate to the fact that the idea of Section 3 was to go after people who were the most responsible for secession and the Civil War, and that tended to include higher level officials. They were seen as basically more blameworthy for what had happened than, say, lower level officials.
I want to ask you just a few final questions. Last Friday, Trump served an expert report in this case by Robert Delahunty. Have you had a chance to review that expert report?
I have.
Describe for us your level of familiarity with the people who today are recognized as experts on Section 3.
I'm very familiar with them.
When was the first time you had ever heard of Robert Delahunty?
When I learned that he would be an expert witness in this case.
How would you characterize Robert Delahunty's contributions, if any, to the scholarly debate on the history of Section 3?
I don't know what it means.
Is Robert Delahunty someone that you would consider to be an expert in this history?
No.
Oh, well, he doesn't know this.
Robert Delahunty cites an article, a law review
Your
article.
Honor, I'm going to object to this entire line of questioning. This was not part of this expert report. It's wholly improper.
Your Honor, we got his expert report at midnight on Friday, and I understood that we were able to do short rebuttal or response to that since we did not have a chance to respond in writing.
Your Honor, he may contend with Professor Delahunty's arguments if he sees fit, but he is not an expert on Professor Delahunty's expertise. He is not here to render an opinion on whether he's a better expert than Professor Delahunty is a better expert.
It sounds insane.
Or Professor Delahunty is a better expert. So I understand that some experts think they're. No, I won't say more. Thank you.
The court will sustain an objection to the extent that I agree. I don't think it's proper for one witness to comment on the other witness's expertise. And that's what you do in cross-examination. However, I will allow the professor to talk about his response to the opinions of Professor Delahunty.
That's actually a fair response from the judge.
Thank you, Your Honor. One of the sources that Professor Delahunty relies on is an article by Professors Blackman and Tillman on the question of whether or not the presidency is an office under the United States. Is that an article that you're familiar with?
I am.
Can you situate that article in the broader scholarly debate surrounding the history of Section 3?
Well, I mean, of the draft papers that have considered the question of whether the president is an officer of the United States for purposes of Section 3, and there aren't that many, I would say that their position so far is in the minority.
Tell us who some of the other scholars are who have addressed this issue and disagreed with the Blackman and Tillman position.
Yeah, so there's.
That's not a logical argument. This isn't. This is a logical fallacy.
I mentioned earlier the draft paper by Professor Graber.
Of appealing it
that
to
I
authority.
referenced earlier. There's another draft paper by John Vlalopoulos, I believe is correct pronunciation.
This is an appeal to authority.
And they all take the view that the president is an officer of the United States for purposes of Section 3.
Okay.
I want to ask you about a few other
these
sources
other experts say
that are cited in
That's-
Mr. Delahunty's expert report. I want to pull it up on the screen here. Petitioners Exhibit 227. If we go to page 10, there's a discussion of the presidential election of 1872 and the candidacy of Horace Greeley, which I think was also referenced in opening statements. Have you reviewed this portion of Mr. Delahunty's report?
Yes, I have.
And tell us what you understand to be the argument about Horace Greeley in 1872.
Well, I understood the argument to be that Horace
Thank
Greeley ran for president in 1872 as a Democratic nominee, and no one objected to that on the grounds that he was ineligible to do so under Section 3, and that therefore that might mean that Section 3 does not apply to.
Do you agree with that argument?
No.
Why not?
Horace Greeley was not a Confederate. He was a loyal supporter of President Lincoln during the war. He was a supporter of radical Republican policies during Reconstruction early on. He was a supporter of the conviction of Andrew Johnson in the impeachment trial in 1868. Section 3 had nothing to do with him.
Didn't anybody kind of criticize him for Southern sympathies, though?
Yes, but I mean, that was just sort of political rhetoric that people were putting out. And, you know, there's a distinction between that and the sort of legal ineligibility that would attach to Section 3. Now, for example, John Bingham gave a speech in 1872, a campaign speech against Greeley. He was campaigning for Grant's re-election, and he expressly distinguished Horace Greeley, whom he opposed, but basically he could be president if he won, from Jefferson Davis, who he said could not be president because of Section 3 of the 14th Amendment unless Davis got amnesty. So, pretty clear, Davis was a Confederate, he was ineligible. Greeley was not a Confederate, he was eligible.
And let's, I know you've said that Horace Greeley was not a Confederate and so wasn't covered by Section 3, but let's assume for the sake of argument that he was otherwise covered by Section 3. What, if anything, does the state of amnesty by the time of the 1872 election tell us here?
Well, if Greeley had been covered by Section 3, he would have received amnesty under the General Amnesty Act that was enacted in the spring of 1872. So Section 3 couldn't have applied to him anyway while he was running for president.
Does the example of Horace Greeley tell us anything here?
No.
There's also a discussion in Mr. Delahunty's report citing to an article by Professor Kurt Lash about earlier drafts of Section 3 of the 14th Amendment and whether those shed any light on whether the presidency is covered. Are you familiar with those arguments?
Yes.
And what is your opinion on those arguments from a historical standpoint?
Well, they're inconclusive, right? That is to say, you can't draw a conclusion from early drafts as to what the final draft means, unless somebody says, the reason we're changing the draft from this to that.
It depends on what the early draft says. If they specifically carve out the president, then yeah.
Such commentary about the differences between early drafts and the final draft.
That's insane. That's insane to make that as a general statement.
And so therefore, you really can't draw any conclusion about the final draft from any of the earlier drafts.
This is when an
Is there
intellectual
any indication that
thinks
you've
that they're
seen
so
in any of the
intelligent
congressional debates about Section 3
that they can just ignore
that
what's
anyone
staring them in the face?
intended to exclude the president or the presidency?
No.
I want to turn to page 30 of the report. There's a discussion here of 3 sources identified by Professors Blackman and Tillman that they cite to suggest the president is not constitutionally an officer of the United States. Did you review that portion of Mr. Delahunty's report?
I did.
Were those historical examples persuasive to you?
No.
Oh, surprise.
Why not?
Well, a couple of reasons. I mean, first of all, they all arise a decade after the ratification of the 14th Amendment. They are not about Section 3, the second reason. Now, third is, I don't know who David McKnight was. I mean, but put another way, he's not Noah Webster or Francis Lieber, so he doesn't have the same sort of authority. So the
But some dude from Maine who was a member of the Congress in Maine in 1868, he knows him well.
The other two statements came out of the Senate impeachment trial of Secretary of War William Belknap, that he was accused of corruption, among other
His
things.
eyes are creepier to me than his
And
ears.
The thing is that, first of all, that was a trial that was not about the president. So the statements by the senators that the president was not an officer of the United States were kind of dicta, basically, that had nothing to do with the trial that they were involved in. Now, let's contrast that with the statements about this issue in the impeachment trial of Andrew Johnson. Now, that happened in 1868 when the 14th Amendment was ratified. That was about the president. He was on trial. People did say that he was an officer of the United States. His own lawyer said it, as well as members of Congress. And it was an actual issue in the trial. And the reason for that is that President Johnson was accused of committing a high crime and misdemeanor by refusing to follow an act of Congress because he thought it was unconstitutional. Okay, so set aside what you think of that argument. Part of making that argument meant saying, well, he wasn't a judicial officer. And only judicial officers can set aside laws because they are unconstitutional. He's only an executive officer. So that was part of the reason why people were.
Oh my God. Why would they exclude the word president? Just because he's referred to as an executive officer doesn't mean that when they're referring to officers later in the statutes, it's referring. This is so stupid. This is what I meant. This is an intellectual tying himself into knots to try and support his own argument. I'm going to take.
I want to briefly ask you about
here, this
Professor
Tennessee
Delahunty's
judge
argument
over
that
here.
Section 3 is too ambiguous for courts to decide without congressional implementing legislation. Do you have a view on that issue from a historical standpoint?
Well, yes. First of all, we see examples of people applying Section 3 and interpreting it at the time. Right? And so, in the end, it's really no different than a lot of other legal standards, which are broad, and you have to figure out how to apply them to a particular set of facts. But that's what we do with standards like that. Now, it would be nice if we had more examples, more cases to guide us. But I had a colleague, she's no longer with us now, but when people would say, why don't we have more information before we make a decision, she'd just look at you and say, alas.
Oh my God, his eyes.
Like that, we have what we have, but we have to work with what we have. But there's no reason to think that we can't work with what we have.
Do you agree with Mr. Delahunty's argument that the phrase insurrection was ambiguous at the time?
No, I mean, we've gone through quite a bit of material to define what insurrection was. And, that doesn't mean we know how it should be applied to every set of facts, but there's quite a bit of material that defined what insurrection was as of Reconstruction.
Do you agree with Mr. Delahunty's argument that the phrase engaged in insurrection does not include speech?
No, I do not.
Mr. Delahunty cites the Second Confiscation Acts in making that argument. Can you explain to us what the Second Confiscation Acts were and kind of what you understand that argument to be?
Sure. The Second Confiscation Act was a criminal statute enacted in 1862 that defined insurrection by listing a series of terms, including to set afoot, to incite, to engage. And then my understanding is the argument is, well, Section 3 did not include the word incite in its terminology in the way that the Second Confiscation Act did, so therefore maybe incite was not included by Section 3.
Do you agree with that argument from a historical perspective?
No.
Why not?
Well, first of all, I mean, there's a difference between a criminal statute, which is what the Second Confiscation Act was, and the provision of Section 3, which is creating a new qualification for
But they
office.
have to penalize them for a criminal act.
Not that close. Secondly, there's no explanation in the debates on section 3 as to why the word incite was not included. So again, it's like you can't really.
This is twisting yourself in a knot again.
From a prior version, right?
You actually can draw a conclusion from the fact that it's omitted when it is included in other acts.
Thirdly, constitutional provisions are not statutes. They are not as specific as statutes. They're written in general language.
Well, it specifically says senator. It specifically says member of the House. It specifically says elector of a president. So it's pretty specific.
Constitutions as specific as statutes because then they would be.
It's broad where we want it to be. It's not broad where we don't want it to be.
So, constitutional provisions like Section 3 were written in general terms.
What, if any, conclusion do you draw from the fact that Section 3 does not specifically mention incitement?
I don't draw any particular conclusion from it. I draw conclusions from the other sources that interpreted Section 3, mainly the Attorney General's opinions.
My last question for you is, if we step back and evaluate Professor Delahunty's historical methodology laid out in his report as a whole, what is your opinion as to the reliability of his historical method?
Your Honor, we will.
Sustained.
I think he's wrapping up.
Professor Magliocca, you discussed earlier the types of historical methodologies that scholars in history typically follow when they are deciding historical questions, correct?
Yes.
And can you tell us whether or not, in your view, Mr. Delahunty followed those prescribed methodologies?
This is what I meant by gaslighting. It's that he actually believes it says what he says, even when the words are clearly don't say that. But intellectuals tend to tie themselves in knots, say, no, this is why, because it's like this, and it's like.
You can cross-examine Professor Delahunty on his.
Understood, Your Honor. We don't have any more questions. Thank you.
Told you he's wrapping up.
Cross-examination.
Here we go. Get him. Get him.
Good morning, Professor Magliocca.
Good morning.
Good. Okay. I'm glad that Scott Gessler's the one doing this one.
You may proceed.
This one's important.
Sure. So you've been on the witness stand before, correct? In the Georgia case, if I remember correctly.
You lost
okay.
that.
Have you been a witness in any other instances?
No.
Okay. So you know
That
how
argument-
this works with me asking a few questions.
When you were on that
And
case,
thank you for being here today.
Did you
So I
have
want to ask a
Marjorie Taylor
little
Greene
bit
out?
about sources. You'd agree with me with respect to the 14th Amendment in Section 3 that there's recently, within the past few years, a substantial amount of new scholarship on that issue.
Yes.
Okay. And you mentioned that your view that the Tillman and Blackman viewpoint is in the minority, correct?
Yes.
Okay. And you would agree with me that when courts make decisions on interpretation, they don't count up the number of professors on one side of an issue versus the number of the other side and make their decision on that basis.
Well, no, it's not the only factor.
Well,
it
it's
shouldn't be a
probably
factor
not
at all.
even one factor. They look at the strength and the quality of
sad
the
if that is
underlying arguments,
a
correct?
factor at all.
Okay.
Yeah.
Now, you and I had chatted just very briefly, and you're familiar with Professor Blackman, correct?
Yes, I know him and I like him.
And you two have mutual admiration for one another and mutual respect for one another's scholarship.
Yes.
Okay. And you still have some pretty sharp disagreements on the meaning and application of Section 3. Is that fair to say?
Yes.
Okay. And it's fair to say that you two will continue to have discussions, continue to disagree, perhaps sometimes resolve your disagreements as part of the scholarly and analytical process.
Probably later today.
He may even be listening to your testimony today. Okay. And then you'd agree with me that that scholars such as yourself and others will continue to analyze the historical record and sometimes modify your opinions based on what you find, correct?
Yes.
Okay. And in fact, there's one instance where Professors Bowden Paulson quoted the historical record of the case of Jefferson Davis. Are you familiar with that?
Yes.
Okay. And Professors Tillman and Blackman looked at the history very closely and said the actual record, this record written with respect to Justice Chase's ruling, was incorrectly recorded. Do you remember that?
Well, they made the argument that it was incorrectly recorded.
Okay. And so what they did is they compared an 1869 version from an American Law Review to an 1894 version and said, look, the 1894 was essentially that sentence with respect to Section 3 was inserted, we believe, incorrectly.
Well, yes, now that's a bit more complicated in the sense that, I mean, first of all, it's not clear that it was inserted incorrectly. Because if you look at newspaper commentary at the time, I mean, there was somewhat of a mixed set of views about what Chief Justice Chase was saying in that case or thought about it. Secondly, it was actually pretty common practice back then for comments to be inserted in official reports years after the fact. In my book on Bushrod Washington, he would revise his reports, or he had someone who helped him edit them, years after the fact to change them. And so today, they didn't have an official set of reporting systems the way we do now, right? So today that would seem, well, improper or very odd, whereas back then it was more common. So yes, but they've made that argument, right?
And so the point I'm trying to make, and I'm assuming you will agree with me, but I'll ask you if you agree with me, that there's still substantial debate about the accuracy or the quality of the historical record in some instances with respect to Section 3.
Yes.
Okay. And you'd agree that you have a pronounced point of view and some other scholars have different points of view on that issue.
Yes.
Okay. Now, my understanding is that you have not rendered an opinion, nor have you been asked to render an opinion on the meaning of the word incitement.
That's correct.
Okay, or incite, or any variant of that.
Right.
And so your argument is that insurrection can include words of incitement,
Yes.
but you're not necessarily defining what incitement is.
Correct. I'm not a First Amendment expert.
Okay. Excuse me one moment. Could you do that one or two, please? And is it, just to understand sort of your definition of insurrection, in order to engage in insurrection, in your view, does that require an overt and voluntary act?
Well, an overt or voluntary act would constitute engaging in insurrection. I mean, whether inaction was just not something that was addressed, so history doesn't tell us the answer.
Okay. Could someone engage in insurrection with an involuntary act?
No.
Okay.
So what would they have to say, Bob?
Could someone engage in insurrection with a secret act?
Well, no, in the sense that there had to be some public action that was involved, probably in the sense that there was a public use or public purpose to the insurrection.
Okay.
Yeah, I would tend to think not.
So you'd agree with me that it requires an overt and voluntary act?
Well, an overt and voluntary act would qualify, yes.
Okay. And that someone has to have a specific intent.
Well, that's a question on which the sources don't give us a clear answer. The Attorney General's opinions do refer to intent. On the other hand, the cases don't.
The cases, to some degree, could be understood as saying that awareness or knowledge is sufficient. The reason I say that is because, let's say you had a sheriff, okay, in a southern state. They were the sheriff before the Civil War. They maintained the same position during the Civil War and after the Civil War. So doing the same job the whole time. All that's changed is, they were in the United States, they were in the Confederacy, they're under the United States. It's not clear there's any intent involved, but they would have been disqualified because they had served prior to the war, now they're serving during the war, now they're still there after the war. It is clear that they were aware of the insurrection, right? But they were just doing the same job in the same way. So it's less clear that would constitute intent.
So let me ask you, because there's a couple of branches of Section 3, right? There's the aid and comfort to the enemy's branch, and there's the engage in insurrection or rebellion.
Yes.
Okay. So are you saying it's unclear whether or not that sheriff engaged in insurrection? Or
The sheriff was deemed to have engaged in insurrection.
Okay.
My point was you can't say that there's any specific intent involved there.
Okay.
Never know.
Because he was exercising civil authority under the government of the Confederacy.
In the same way that he did before and after.
Are you familiar with Professor Kurt Lash? Well, you are familiar with Professor Kurt Lash. You two have
You guys have to
either
stop.
written
You're
an
killing me
article
here.
together
I'm
or
trying to
served on a
concentrate.
panel?
We did a podcast together. Yes.
Okay. And he recently wrote an article sort of talking about the historical record of Section 3, correct?
Yes.
And you'd agree with me that he uncovered some aspects or some items within the historical record that were relatively new to scholarship.
Well, yeah, I think every draft paper is able to do that, yes.
And that's just part of the advancement of scholarship. Each draft paper adds new information.
Right.
Okay. And have you been in correspondence or spoken with Professor Lash since he wrote his paper?
I have, yes.
Okay. And that's a collegial relationship similar to the one you share with Professors Tillman and Blackman. Would that be fair to say?
Yes.
Okay.
Now, you want to be careful when you're doing this cross because you are going to have your own expert, that guy Delahunty, coming up there to refute him. You don't want to really ask him anything about what Delahunty is going to say. So you're sort of hamstrung because Delahunty is going to say all the arguments that you would bring up here on cross. So this is a little bit of a tricky cross, trickier than yesterday's, because in this one where they're expecting to have their own expert refute them. So you don't want to open the door to enable this guy to further try to undercut the arguments that Delahunty is going to present. So rather than trying to basically say you're a lunatic who thinks, like the one yesterday, the guy basically came up there and said, if Trump says something that could be twisted by somebody saying 1776, it means murder and kill everyone. And if he says, when he says we're gonna protest, that means we're gonna stab as many people as we can.
Let me just ask you one more question, or just another set of questions on the First Amendment issues. The word within sight. So did I correctly hear it saying that you're not here today as an expert on the First Amendment?
Correct.
Okay, so you've not, for purposes of today, maybe at some other point, sort of done an analysis of what incitement means or the historical record behind that.
There were no First Amendment cases from the Supreme Court until well after Reconstruction. So that's part of the reason why.
Okay, so basically, the historical record you've looked at predates modern First Amendment law.
Correct.
Okay. All right, I have no further questions. Thank you very much.
Like I said, I didn't expect his cross to be as fiery here as yesterday's.
Very briefly, Your Honor.
I'll just hit this up real fast. A little chauffeur. This guy's a pointy head envisioning a $24 coin on top of that pointy dome. That's right, $20 chauffeur blast for you.
You were asked about
Blow that
Professor
horn.
Kurt Lash.
Good
Remember
tinfoil.
that?
Thanks for the support, Chief Hasbin.
Have you reviewed Professor Lash's draft paper on Section 3?
Yes.
Can you tell us whether anything in that draft paper changed or affected your opinion on what insurrection would have been understood to mean at the time of Reconstruction?
No. He didn't really address that very much.
Can you tell us whether or not anything in Professor Lash's paper changed your opinion as to what kinds of conduct was sufficient to have engaged in insurrection?
No, we didn't really address that much either.
Can you talk to us just very briefly about what the time period was that Professor Lash looked at?
Well, I mean, he was mostly looking at 1866 to 1868, although he did talk about a few other things, including the, of course, really the example that Professor Delahunty also referred to in his expert report.
Can you tell us whether or not, in your opinion, the time period he looked at in his article was sort of the whole body of historical evidence?
Well, I mean, mostly, but not identically, right? That is, in other words, the time period that we're really all looking at is pretty much between 1865 and 1872, when Congress passed the general amnesty. I mean, maybe one or two things after that, but very little. So his paper covers, much of that period, though not, I would say, not certain things that came kind of towards the latter end of that period.
Thank you, Your Honor.
Does the
So
Republican Party have any questions for Professor Bagliocca?
We have no questions.
So like I said,
No questions.
you on cross there, you're really forced to like sort of walk very carefully because you don't want to open a doorway for him to start coming up with some new points that he hasn't raised on direct in an effort to refute any points that your expert is going to raise. So in that sense, you're sort of very hamstrung. You're very, very hamstrung. As opposed to yesterday, when they had an expert up there on far right-wing extremism, where you want to make that guy exhibit what a joke he is. That if Trump
Good morning,
says
Your Honor.
something,
Our next witness is Hillary Rudy, and she is not in the courtroom yet. She is walking over at this very moment.
let's take a break for like 10 minutes.
Why don't we take our break then, a little bit early and reconvene at 10:15?
Okay, thank you.
Let's get a 20-minute break here. Okay, good. All right. So as counsel there for Trump, you really wanted yesterday to basically show all the testimony this guy's giving. He's clearly going to take anything that Trump is saying as being some sort of dog whistle toward inciting the mob to go hang Mike Pence or kill Congress or whatever. So that's why, and during the course of his testimony, that expert was basically saying how he understands the mindset of the 3%ers and the Oath Keepers and and the Proud Boys, and that he spent nights with them and hung out with them and went undercover with them, and that he was like this guy who understands that they have their own language and it's a coded language, which to you or me may sound completely innocuous, but to them, they understand that it's a code word saying go out there and get them, and that this is, and gave a bunch of words that he was saying are basically insightful type of words that Trump would say. And that they understand that when he says fight, that when you say fight to them, that's different than when everyone else says fight. So that's why Trump now is inciting them, and that the leaders typically will use humor to mask what they're saying in order to try, even though when they're using humor, everyone knows what they really mean, and that that's actually serious. And he used examples of Nick Fuentes and Alex Jones and Tim Pool. Yeah, Tim Pool. That's right, Tim Pool, as showing that that this whole thing with January 6th is going to be wild, and they're building up to it. And this guy is inciting. Basically, he has Trump inciting January 6th. I don't know, all the way back from like 2015 when he's sitting in some interview. He's dog whistling all the way back then, planning for January 6th, before he even announced his candidacy 5 years earlier. But and then when he says anything that could not possibly be twisted into anything other than don't fight peaceably, kind to the police officers, all that other stuff. That's the fig leaf veneer that he's trying to use to have plausible deniability. And then if he says nothing in response to like somebody who's screaming, "Hey, we have to stop the violence," he doesn't say anything about it. Oh yeah, that's going to be held against him. It was, no matter what he said, it was further proof of incitement. And he basically showed how ridiculously twisted this was, where any word that he says, any statement he makes, it's like, well, that's incitement. That's trying to incite them also. That's trying to incite them also. So, and he did a great job of that on the cross-examination. It was brilliantly played by Scott Gessel. Really phenomenal lawyering. That's a guy who you want to show that you're reaching these conclusions, and these conclusions are basically start with confirmation bias. In fact, he was actually asking him about confirmation bias, and the guy didn't even realize that it was obvious that he was talking about the witness's own confirmation bias. And the witness thought that he was talking about confirmation bias of the oath keepers, whereas, and he's like, oh yeah, confirmation bias can be a real problem where people don't even realize what it was hilarious to watch. It was hilarious. It was brilliant work by Scott Gessel. Seriously. If you missed it, I would highly recommend you check it out. It was at the last hour of my first show and the first hour of the second show where he just shredded him. And that's what you need to do with that type of expert witness, because you basically want to show that everything he's expressing here, which is rooted in his opinion of stuff, is something that is he easily displayed his bias. Now, with respect to a historical researcher about the language that's being used in a statute, so he's coming to this conclusion, and yeah, is he twisting from here and from there and pulling from this Tennessee judge and this member of the House in Maine and this purported argument and rejecting this other thing? He's acting now not as someone who's saying, "Oh, I was undercover and I'm going to try and like basically present this twisted thing," even though I'm positive that this Ferengi who just took the stand was 100% twisted against Trump long before January 6th. It's obvious. It's obvious because he's twisting himself in knots, trying to come up with different ways of like, well, then they left this out because officers there, and they had this magic find of debate that they had in Congress about, well, why don't we put the word president in there? And it's no, because it says officers, and even though it says expressly no senator, member of the House, elector or president, the senator's not an officer, member of the House not an officer. I ask. Why would you just leave out the word president? Earlier drafts, which I think the earlier draft specifically said president, cut it out. We'll hear from Delahunty on that. But if it did, to me, that's a slam dunk. If the earlier, he's like, no, early, when he has to dismiss earlier drafts, that means that this guy really, 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 really doesn't like the earlier drafts, because they imply that the earlier drafts, which were rejected, was basically what the final language they come up to is basically saying, we don't like these words, we're going to take these words instead, because we can't agree that the first draft is something that would pass in Congress. So yeah, is this guy twisting left and right? Yeah. But when you're going to have your own guy come up there and testify and show his position as to why it is that there's no way that this statute could possibly be referencing President Trump for inciting insurrection based on the language of this statute, you don't want to give this guy that much more of an opportunity to circle around that, or to bash your guy's arguments in advance of him making those arguments. As opposed to yesterday, instead of the bash coming from a subsequent witness, the bash actually came from the lawyer himself. So that's the distinction there, and that's why I think he was a lot more careful and a lot briefer in this cross-examination, which I think was the right call. I think that was the right call. Let me just cover a couple of these. Sounds like my logic's X, to be honest. Oh, there was a few Rumble rants I wanted to get to. Katie Dougherty just started following you after I saw you on Riquetta Law yesterday. Yeah, we had a fun show. That was great. And I'm glad that you jumped on board. Welcome to the following. Katie Dougherty. One moment. Sorry, I just heard Lady Logic calling me. Also had Tatone saying this expert's entire testimony hinges on Trump, quote, inciting insurrection, means he meets disqualification clause. The Senate already acquitted him of inciting an insurrection. Well, he was he later, you wrote, I know you wrote this earlier, before they talked about incitement, and he basically admitted, he's like, I'm not talking about incitement, I'm simply saying that the statute applies to him. So then you have to figure out and apply, and if he did incite, in that case he would be considered to have and he would consider to be disqualified under this section. And he also tried broadening insurrection to include what happened on January 6th, even though that's not an insurrection the way anyone understands it. We're trying to say any group of people trying to stop any law of the United States from being affected is an insurrection, which is a very, very generous read. And Endug saying, thanks for streaming this, Joe, even though it makes me very angry. LOL. Oh, and the ghetto says hi. Hi, ghetto. Hi, ghetto. I think she's referring to the Rumble ghetto, which is not a ghetto. You know, I love you guys in Rumble, even though you never hit like on my, you know, I can't beg. I like have to actually go to your houses to get you to press the thumbs up button and knock on the door. Hi, this is Good Logic. Can you please put a thumbs up on my video? I'd really appreciate it so that like more people might watch this trial in this coverage that you're enjoying. If you could just do that for me, I'd really. Okay, Joe. I guess I'll do that. How did you find me? I had to do a lot of research. I probably called an investigator and found out that Real Patriots Party lives over. I don't know where you live, Real Patriots Party. There's no investigator, but yeah. Anyhow, so, but I got 694 watching me over on. If you can also give me a follow while you're there, God bless you. God bless you. I'm trying to march to 10,000. The only chance I ever have to grow, I know, is when I do trial coverage. So if you're here, whether it's on YouTube, whether it's on Rumble, or you want to follow me over on Locals, which is goodlogic.locals.com, where I got. I mean, the memes of this guy's face are dropping everywhere. They're dropping Dobby. Oh my gosh. And these Dumbo ear people. Oh my God. Yeah. So that's over at goodlogic.locals.com. This trial, I'm supposed to be joining up with Viva Fry at 1:00. I don't know how that's going to work. He sent me a link. He's now interviewing someone, I don't know, some MP from Great Britain, because I don't know, he cares about things outside this country. And I don't know if I was like, am I coming to you? Are you coming to me? He's like, he said to me yesterday, he's like, don't worry, we'll work it out during the show. I'm like, okay. Anyway. There sounds like my ex's logic, to be honest. Well, no doubt. There goes Joe pandering to big Star Trek again. Always pandering there. Wims, thanks, Joe. Appreciate the walkthrough. I'll have to listen again when I don't have to pay attention to work. Yeah, yesterday's cross was masterful. Really, really, really excellent. I highly recommend that you check it out. Beers and BS, new member of the Following. Welcome to the Following. The Following is not a cult type of cult. You know, there's a lot of bad PR we got where everyone's like, oh, wow, that's a very culty cult you got going on there, Joe. It is not a culty cult at all. It's like the least culty type of cult. I don't know what I could do to make it less of a culty-ish cult. I specifically told our groundskeeper that we're not going to be issuing robes to anyone or tracksuits. No flower wreaths on the head. It's so not a cult. But for $30, you can get a standard issue NYPD hat. Anyhow. Hello, Captain Spaceman. Everyone's going to like wear their NYPD hats while watching me. Like they're like Captain Spaceman back in the 1950s. Let me make sure that I'm not losing her, because this is the thing that I want to just I'm trying to cover this trial. So one of the things that's the biggest challenge in covering this trial, and I'm not exaggerating, has been finding a stream to snipe. It's been very, very tricky. C-SPAN, every time there's like a 30-second break, this is what it looks. This is what ends up happening. This is what ends up happening. They do this every time. Oh, page timed out. What? Why? Resume playback? Okay. Oh, it's not live streaming anymore. It's all over. They're going to go to a brand new clip. Why? I don't know. Nobody knows. Nobody knows why they're doing that. Why don't they just leave it running for 10 minutes? Show us the clock or something like every other trial court does. No. So I'm going to have as a backup here. As a backup, I'm going to be opening up the court's direct link. The court's direct link, which is here. So she's listed as being, this is what's so weird. They say courtroom 209. Click here to view live stream. This is Judge Sarah B. Wallace over here. Just so you all know I know what I'm talking about. That's the judge. Click here to view live stream. Nope. Nope. Click here. Oh, come on. Come on. Click. Little circle going on up here. Your download should start in a few seconds. Install the... Launch meeting. Join from your browser. Oh, really? I have to join this thing. Give me a second. This is my backup in case C-SPAN sucks, because sometimes they start up very late. I'm going to put in my email address. I have their stupid little codes. Oh my God. Look at this. I have to like become part of this stupid thing. Okay, I'm going to just go on the record and say this. I'm sure I'm not alone in this. I have to join WebEx, Cisco WebEx, to join the meeting to watch this trial directly from the court feed rather than from C-SPAN. They want me to fill in characters. To me, is this a B? Is this a 6? I don't know what I'm looking at here. Is this a B? Is that a 6? Is that a B? Is it a 6? I don't know. I'll try B. R-H-Y-N-N. You say 6? You all saying 6? All right, I'll trust you on the 6. Hey, look at you. Thank you. I always guess wrong. Agree. What do I want? What do I want? I'm going to do a microphone. I don't know what that means. What am I? Click allow to allow. I want to do this. What? What? No, I don't want to. What? I don't want to join a courtroom. This is such a disaster. After the host admits me. I think I'm going to court here. I think I'm going to court in Colorado. I'm such a fail at this. What the hell? You all saw how I got here? You all saw? This is... I don't... Why can't I just want to... Let's forget that. That'd be so awesome. Hello? I'm still in there. I'm waiting for someone to admit me. Oh my gosh. All right, I'll come back to that. All right, let's see if they have a new thing here. Oh, here it is. That's 12:15 p.m. Is this it? Watch live. Stop here, Norton. God, not restarting. Greenhouse, stay for the boomer asset. Shut up. It's not like watching an idiot attach on some text message. This is much harder than that. I'm still sitting here in 2nd Denver courtroom 209. There you go. Airing details 12:15. It's 12:15 now. It's 12:15. Let me refresh it. It's 12:15. I think I should leave this meeting. That's my gut is I should leave this meeting here. The big hair dude heard me. Someone should do a meme of Professor John Ozempic, Fetterman, and share credit with me because I'm hilarious. If you do it, please make sure you share credit with Tara. A robot is challenging to see if you're a robot. Yeah, pretty much. That's pretty funny. I never thought about that. The attorney is about to grab the witness by the ears and Perry Mason his face so hard. I hope they hear your voice in the courtroom. Me too. Chugi, Joe, I don't have to download anything to view 1 second while I DM you a better link. You gonna DM me a better link? Okay. So let me get out of this. Get out of this. Leave. Let's see if I download it. Oh my gosh. Oh my gosh. Let me see what you're sending me here. Meanwhile, Viva is saying to me, my God, this is a disaster. This is such a disaster. Let me see what's going on over here. One moment. I'm not seeing your download. I'm refreshing this thing. Oh, God. Come on. That's my Cisco. Please select the county from the drop down on the right or select one of the live streams. Which freaking live stream? Which live stream? Jugi. Denver Courtroom 209.
State and federal elections. And our role is to certify the content for state and federal offices to the ballot, to certify it to the county clerks, to oversee the county clerks in each of Colorado's 64 counties in running elections, to ensure that they comply with all of the legal requirements, to provide training and support in that.
Thank you.
And just to generally ensure that they have what they need to run the elections, and
I
then
don't like this
certify the
view.
results for statewide contests.
Okay. I'm going to ask you a couple of questions about some of those roles, but first, in the Secretary of State's role in administering elections, what role do the courts play in that process?
So the secretary makes decisions with respect to candidate access to the ballot, with respect to certifying results, with respect to a lot of things around the election. And there is a role for the courts when somebody wants to protest a candidate's qualifications, protest the outcome of an election. There's a
This
role for the
redheaded
courts at
woman is one
various
talking.
parts throughout the elections
over here.
calendar to basically make a decision if somebody is protesting
here.
a determination made by the Secretary of State.
And once a court makes a decision, what does the Secretary of State's office do with that decision?
Well, once a court has made a decision, then the Secretary's office conforms to that decision. So if a court decides that the Secretary decided incorrectly at the outset, then the Secretary's office will correct that. Or
I
if
said her name was Hillary
the
Rudy.
Secretary's decision is affirmed, then we will move forward with whatever that determination was.
And is there a particular statute that people challenging a decision of the Secretary of State often use to present issues to the court?
Well, there are a number of statutes that allow for a challenge of the Secretary's decision throughout Title I of the Colorado Revised Statutes. But depending on how near we are to particular elections deadlines, typically Section 113 is used to challenge something that needs to be cited quickly.
Okay. And for demonstrative purposes, I'm going to pull that statute up and ask you some questions about it. Could you pull up Colorado Revised Statute 11113? And I in particular just want to start with Section 1. First, let me ask you, how familiar are you with Colorado Revised Statute
So I think she's
11113?
her objective here. The
I'm
objective here is
Fairly
to
familiar. I
get
don't have
this
it
woman
memorized, but
to
I'm
say the
aware
Secretary
generally
of
of what it
State.
says.
The court is
And you're a
authorized.
lawyer by training, correct?
The Secretary of
I have
State
a law degree, but I don't
determine that
practice.
Right.
someone's ineligible for the ballot.
In 11113,
I don't.
I
like
just
this
want
angle
to
at
ask
all.
you a
I'm gonna
couple
go-
of questions about some of the provisions in Section 1. So you see Section 1 there on the screen?
Yes.
So it says, when any controversy arises between any official charged with any duty
gonna
or
see if I can get
function under this
C-SPAN up.
code and any candidate or any officers or representatives of a party or any persons who have made nominations, or when any eligible elector files a verified
Dean,
petition in a district
I
court.
just want to
of
ask you a
competent
couple of questions
jurisdiction
about
alleging that a
some of the
person
provisions.
charged with a duty under this code has
All right.
committed or is about to commit.
So I'm gonna just stop this, and I'm gonna bring up the C-SPAN feed because I like their feed a lot better.
In Section 1. So do you see Section 1 there on the screen?
Yes.
So it says, when any controversy arises between any official charged with any duty or function under this code and any candidate or any officers or representatives of a party or any persons who have made nominations, or when any eligible elector files a verified petition in a district court of competent jurisdiction alleging that a person charged with a duty under this code has committed or is about to commit. I wanted to ask you how your office Yes, Mr. Gessler?
But we'll first have to finish the petition.
I wanted to ask you how your office has interpreted the committed or is about to commit language.
Your Honor, we would object this to testimony on legal interpretation of the statute.
And I'm gonna overrule it because I don't think she's testifying as to what it does, just how it has historically been interpreted by the Secretary of State. I'm the one that's gonna have to decide what the actual effect of the statute is.
I guess that's fair because that's a factual thing. Like how
Do you need
did
me
they
to
do it?
repeat the question or do you remember it?
If you could repeat it once.
I was asking how the Secretary of State's office has interpreted the language, has committed or is about to commit a breach or neglect of duty or other wrongful act.
In general, the office has interpreted this to mean that if the office has made a decision with which any of the parties listed in the statute disagrees with respect to conducting an election, that means they have the right to challenge that decision in court and receive a decision.
Okay. And in your experience, have people using 11113 to make challenges done so both before an act has been taken and after an act has been taken? So the about to commit language and the committed language?
I can't think of specific examples, but generally speaking, yes, I think leading to an election, that has happened.
Okay. Take you back to my question about what role the Secretary of State's office has in the administration of elections. You described a broad role, and are those
Shut up.
duties and powers of the Secretary of State set forth in statute?
Yes, generally speaking, they're set forth in section 1-1-107 of the Colorado Revised Statutes. There's also a provision in Article 1.5, which discusses the Secretary's authority specifically with respect to federal elections.
Now I'm going to turn to ask you some more questions about ballot access generally. You testified that that is one of the functions of the Colorado Secretary of State's office. So more specifically, what role does the Secretary of State's office play in candidate ballot access?
So our office is the filing office for state and federal offices for individuals seeking access to the ballot, seeking to run for office in Colorado. So we receive that paperwork, we verify the information on the application as required under state law, and then ultimately there is a deadline by which our office must certify all contests of the ballot, candidates and measures.
So specifically, what role does the Secretary of State play in certifying that content for the ballot?
Can you tell me what you mean by that?
So do candidates submit information to you that then you use to certify the content for the ballot?
Yes, so the law requires candidates submit specific paperwork depending on how they're accessing the ballot, whether that's by petition, through assembly, or whatever the nominating process is. And based on the legal
Kills or
requirements of
marries?
paperwork, we will verify the information on paperwork and then set the ballot.
And what is the deadline for the ballot certification for the presidential primary for Colorado in 2024?
I believe it's January 5th.
The angle is so bad though.
Is the process for ballot access, explain the process for ballot access for presidential candidates for the presidential primary in Colorado?
So for the presidential primary election, what the law requires is that candidates access the ballot through one of three methods. The first is through party nomination. So they would submit a candidate acceptance, a letter from the party saying they're a bona fide party candidate, and a filing fee.
If they choose to submit a petition, they would submit their petition.
I'll take a poll.
Before they can circulate a petition, they need to submit the statement from the party that they're a bona fide party candidate.
I'll take a
circulate
poll.
the petition,
On which stream?
And then with their petition submission, they would also need to submit the acceptance of nomination form for the petition. And then the third option is to submit a writing affidavit of intent and a
Has Colorado always had a presidential primary?
no.
Can you explain when we didn't have one and when we got one?
So Colorado had a presidential primary for several years until around 2000.
I can't use both.
It was eliminated in law. And then in 2016, a citizen initiative passed reestablishing the presidential primary and reestablishing it with some specific processes around our current gun ballot.
And where in the law is the process for presidential primary candidates to be placed on the Colorado presidential primary ballot?
It's in Article 4. I don't recall the specific statute citation.
Okay. I'm going to have a copy of that statute brought up just for demonstrative purposes, and that's statute, Colorado Revised Statute 1-4-1204. Do you see that statute there? And does that, just to be clear, does that statute apply to other ballot access candidates?
No, this is the statute specific for presidential primary elections.
Okay.
But is that better video is more important as long as you can actually hear them.
So
we can hear them.
this part of the statute deals with how a candidate gets their name on the
I think
ballot,
it
correct?
gets boring when you feel like you're on radio
Um,
and not seeing the face of.
And you walked through the various processes in your testimony a moment ago.
But I put a poll up there.
What is the Secretary of State's view of whether it may exclude candidates from the ballot who are constitutionally prohibited from assuming office?
It's the Secretary's position that if we have affirmative knowledge that a candidate is ineligible for office, then we will not certify them to the ballot.
Let's talk just a little bit about state legislative candidates and how the Colorado Constitution applies to them, and then we'll talk about the presidential candidates and the U.S. Constitution. What are the constitutional eligibility requirements for state legislative candidates?
Well, there's a residency requirement that the candidate reside within their district for the requisite amount of time. There's an age requirement. And then also
In Rumble, put a 1 if you want better video, a 2 if you want better audio.
Is that they must also be affiliated with the party nominating them or unaffiliated for this.
1 for better vid, 2 for better audio.
And has the Secretary of State's office kept state legislative candidates off the ballot due to ineligibility in the past?
All right.
Yes.
About how many times?
It's a lot of audio. I'm going to switch to WebEx. Just looking at the early results here.
To determine if they have additional information to prove an
Okay.
eligibility requirement, residency, but it has happened.
I'll switch to WebEx.
Certification.
And what happens in that case if someone disagrees with the Secretary of State's decision on candidate eligibility?
In that case, if someone disagrees with that decision, then they can challenge that decision in court.
And is that the Colorado Revised Statute 11113 process we just discussed?
Generally speaking, yes.
Mr. Rudy, would you mind moving the microphone just a little bit closer to
All
you?
right,
Thank
fine.
you.
I'll try putting up, I'll leave this audio running. And we'll try it with the video of the other one.
How frequently are those decisions of eligibility challenged?
You can see it looks
Like
like
how frequently is your office responding to those 11113 or other challenges of candidate eligibility?
I think generally in
I find this
almost every
unsettling.
election in which we're certifying candidates or measures to the ballot, we expect we may be challenged based on our decision to certify or not certify a candidate to the ballot.
She just moved her mic. Maybe it's better now.
So if your office determines that a candidate's records in the statewide voter registration database show that the person is not eligible because they don't reside in the district or they're not of the proper age or some other defect, what actions does the Secretary of State take?
Generally, especially in the case of residency, we correspond with the candidate to see if they have additional information that establishes that they do meet the eligibility requirement in order to determine whether to qualify them or not qualify them to the ballot.
So, and after you engage in the correspondence or dialogue, what happens if you are not satisfied
I'm trying to adjust
after
her
you've
video.
engaged in that dialogue that the candidate meets the qualifications?
I would say that if it's unclear in any way, we're going to escalate to the administration and seek guidance before we make a final decision. But in cases where it's very clear, we'll go ahead and exclude the candidate from the ballot.
And again, if someone disagrees with the Secretary of State's decision to keep a candidate off the ballot, what can they do?
They can challenge that decision in court.
And after a court proceeding, whether it's 11113 or another proceeding,
I think
what does the Secretary of State's office do if a court determines that a candidate is eligible?
audio is ahead of the
Then we'll
video.
certify that candidate to the ballot.
Yeah, you're right.
And
It
conversely,
is.
if someone disagrees with the Secretary of State's decision to put a candidate on the ballot,
I can't move
do
the
they
audio
also have
back,
the same recourse to challenge that decision?
Yes,
And that's a similar proceeding in court?
it's similar, yes, yeah.
And what
though. I can't
does the
adjust this,
Secretary of State do after a court proceeding if the court determines that a candidate is ineligible?
Then the secretary would not certify the
though.
candidate.
Yeah,
to the ballot.
C-SPAN's on delay. So the audio here,
Has the Colorado Supreme Court provided guidance to the Secretary of State
'Cause I'm
on
unsettled
candidate
watching C-SPAN
eligibility
while hearing.
in terms of
WebEx.
past decisions?
I think likely, yes, that's happened, but I can't recall specifically.
Okay. Are you familiar with Colorado Supreme Court decisions
I don't think I can
interpreting
pause.
Colorado's
pause the audio.
ballot access laws?
I'm trying to pause
Yes,
it.
generally.
And is it fair to say that they've weighed in
I only have this
many
live button
times
here.
on ballot access determinations?
I think, yes, generally speaking, I think typically we see that weigh in on citizen initiatives in particular.
Okay, let's turn to presidential candidates now. What is the process to verify the qualifications for presidential candidates?
Our office looks at the information provided in the affidavit itself, and if the affidavit is complete and we have no affirmative knowledge that any of the information is incorrect, then we would qualify that candidate to the ballot.
And
And is this the statement of intent, the affidavit you're referring to?
Yes, Your Honor, the statement of intent.
how many times has the Secretary of State's office kept a presidential candidate off the ballot?
I don't have a specific number. It definitely has happened, and particularly for the general election.
And what does the Colorado Secretary of State's office do with a constitutionally
See, this is
ineligible candidate?
This is a red herring.
What do you mean by that?
Do you not
C-SPAN is like
certify them to
25
the
seconds
ballot in that
behind.
case?
Yes, that's correct. If there's information
that
that they're
video is
not
never gonna catch up with
constitutionally
this audio.
eligible.
Do you remember a
Just because they kept people
Ballot
off, that doesn't mean that's how the 14th
access,
Amendment is supposed
case
to be kept out.
involving a Mr. Hassan?
Yes.
I'm going to pull up Exhibit P107. This exhibit has been stipulated, so I would move it into admission.
Oh, 107's admitted.
Do you recognize this document?
Your uncle's
Yes.
very talented.
what is
I don't know what
this?
to tell you.
This is a
The
letter
video is
that our
off,
office sent to
and the
Mr.
audio is
Hassan
20 seconds
after
ahead.
corresponding with him about access to the general election as an unaffiliated candidate for
And there's
president.
no way to delay it.
And what year was this?
So your uncle's
This
way
was
more
in
talented.
2011.
And how did it come about that Mr. Hassan was kept off the ballot?
Mr. Hassan began corresponding with our office
That's what I
seeking
tried doing
access
text
as an
back.
unaffiliated candidate for president, but notified us that he was not going to fill out the paperwork because he did not want to check the box that he was not a natural-born U.S. citizen. He didn't want to commit perjury, but he did want to seek access and was looking to set up lawsuits challenging that provision in the Constitution.
And what did the Secretary of State's office determine regarding Mr. Hassan's eligibility?
Mr. Hassan told us affirmatively that he failed to meet one of the constitutional qualifications. He also refused to file the required paperwork. And so our office advised Mr. Hassan that if he was in fact ineligible and did not file the correct paperwork, that he could not be a candidate for that office.
I'm going to direct your attention to the third paragraph in this letter.
Yes.
Could you read that first sentence for me?
The Secretary of State
Did
is
the
responsible
Secretary of
for
State's office-
ensuring that only eligible candidates are placed on the ballot and must give effect to applicable federal and state law unless a court has held such law to be invalid.
And is that still the position that the Secretary of State's office takes today in 2023?
It is.
Thank you, Mama, for appreciate your support. Yeah, I pulled up a fresh feed here of. I don't know why I keep losing it.
And can you describe generally what that first sentence in that letter means?
It's way behind
Well, as
the
I
video.
said, the Secretary's office is
She's reading
responsible
that
for
thing now.
certifying qualified candidates to the ballot and for overseeing the conduct of elections for those candidate races. And so our office is responsible for ensuring that
Oh.
we verify to the extent the law requires us to eligibility of candidates before placing their name on the ballot.
And based on that statement, can you confirm that the Secretary of State's office considers both federal and state qualifications when determining whether a candidate is eligible?
Cover your
We
ears.
do.
That was for you, CLS. Just a little something for your efforts. Thank you.
What
Thank you so
position
much.
does the Secretary of State's office take on whether it is the final arbiter of eligibility?
The Secretary's office is never the final arbiter of eligibility because the Secretary's decision to either certify a candidate or not can be challenged in court.
There you go.
And did Mr. Hassan take his case to court?
As I recall, he did.
And
I mean,
do you recall the outcome of that case?
Generally, the outcome
Not
of that
relevant.
case was the court affirmed his ineligibility.
His ineligibility. And
But
so
that doesn't
once
mean
the
they were
court
right for keeping it.
affirmed his
but they already do
ineligibility,
it.
what did the Secretary of State's office do?
We did not place Mr. Hassan's name on the ballot for the 2012 presidential election.
Is the process you outlined for presidential candidates generally the same process for other federal candidates seeking ballot access for congressional or senatorial seats?
Generally speaking, it's the same. For congressional or senatorial seats, we're also required by law to verify residence, party affiliation for
know.
partisan candidates.
I don't know. These are good questions. I don't know who Ben Sisney is.
And aside from Mr. Hassan, have there been other federal candidates disqualified based on constitutional requirements? To your knowledge?
To my knowledge, I can't recall.
That was for you, Thomas.
Let's walk through, you testified a few minutes ago about the general process for presidential primary candidate ballot access. I'm going to have, we're going to look at Exhibit P158, which has also been stipulated into evidence, and we'll look at page 2 of that exhibit.
So now I want to see if I can pull up page 2.
Do you see that document?
Yes,
And do you recognize it?
yes.
What is it?
It's the major party candidate statement of intent for the presidential primary.
And I'd like to ask you some questions about the form itself first, before we talk about the
If they show it on
who's
C-SPAN,
filled
I'll show
out.
it to you.
Um,
I'm watching C-SPAN.
Who created this form?
Our ballot access team within the elections division.
And how long has this particular form been in use by the Secretary of State's office?
This form has been in use since the 2020 presidential primary paperwork deadlines, and this particular version of it since June.
And I see at the bottom, are you looking at the bottom right of the form?
Yes, that's correct.
And does it indicate there when it was last revised?
It does, although it's cut off on the screen that I see.
Oh, okay. Well, there you go.
We'll see now.
Can you see when it
one.
was last revised?
Yes,
When was it?
June of 2023.
And why are these forms revised?
Well, in this case, our office suite had changed, and so we needed to update the suite number to ensure we could receive our mail properly. And we also had transitioned to a .gov domain since the 2020 elections. We
They're
needed
at
to
least
update the
15
email
seconds
address,
behind.
and we updated the year at the top of the form.
And were those the only changes to the form, to your knowledge?
To my knowledge, yes.
And so this is the aside from the email address and the suite number, this was the same major party candidate statement of intent for presidential primary that was used in the 2020 cycle.
Yes.
At the top of the form, well, let me ask you a general question about forms. What role does the Secretary of State's office play in creating forms that are used by candidates for ballot access?
The Secretary's office creates all forms that are used for candidates for state and federal office for ballot access.
All right, turning back to the form itself, at the top of the form, do you see where it says office information?
Yes.
And what is the significance of that language?
Well, generally at the top of each of our ballot access forms, we include information about the
Petitioner
office being
as an
sought,
expert on direct.
so that the candidate is
Not really an
that completing the
expert.
correct
I call him
paperwork,
an expert,
but
but
also for our staff in terms
actually-
of processing that
I'm gonna
paperwork
change that.
and verifying qualifications.
And so underneath that, office
this
information
is really a
says
fact witness.
year of presidential primary election 2024. You see that?
Yes.
So presumably that year was also changed on this form, right?
Yes, that's correct.
And then it lists the political party for the candidate.
Yes, that's correct.
And then there's a section for qualifications for office. Do you see that?
I do.
And what are the qualifications listed here?
The qualifications listed here are age of 35 years, resident of the United States for at least 14 years, and natural-born U.S. citizen.
And do you know where those qualifications came from?
From the U.S. Constitution.
And are you aware there are other qualifications for the president that are contained in the U.S. Constitution?
Yes.
I'm going to turn your attention to about halfway down the form. There's some, oh, it might not be blue in yours. It's blue in mine. There's a bolded word that says signature. And
Yes.
underneath
And I'm going
that,
to point something
there's
out here.
It says
There's
applicant's
a very big
affirmation.
difference between
Can you read
35
that
natural born
affirmation?
citizen versus the 14th Amendment.
I
Because for
intend
the
to run
14th
for the
Amendment, you
office stated
necessarily have
above
to
and
reach
solemnly
factual
affirm that I meet all
determinations as to
qualifications
whether or not there was
for the
an
office prescribed
insurrection,
by law.
whether he engaged
Furthermore,
in
the
it.
information provided
cannot
on
be
this form is, to
self-enacting.
the best of my knowledge, true and correct.
And since it's not self-enacting, that makes it very different from someone turning
And how does
35, which
a
that's
candidate
self-enacting. You have to have
submitting
a
the
birth certificate which
form
shows that you're it's-
confirm that affirmation?
that can be you can take
A
practically
candidate
judicial
would
notice of
sign
that.
that affirmation and have that signature notarized.
You don't need a finding of fact. Imagine
How does
50
the
different
Secretary of
states
State's
trying to
office
determine
view
whether or
that
not there was an
affirmation
insurrection.
when
That's what this
considering
court
a
is basically
candidate's
contemplating. Should 50
qualifications?
different states decide whether there
Can you
was an
tell me what you
insurrection?
mean by that?
How
Well,
stupid is that?
That affirmation states that the person meets all qualifications for office. So does the Secretary of State's office interpret
50
that
states
to
will agree
mean
that someone's
more
35 or
qualifications that are
not.
listed on the form?
They usually can easily
The
agree as
qualifications
to whether or
listed
not
on the
someone's a
form
natural
aren't
born
intended to
citizen.
be an exhaustive list of qualifications.
But
But
these
we do require that
qualifications
every
is something that
candidate
not
affirm
all
that
50
they meet
states
every
will,
qualification
it's
for office,
foreseeable that
regardless of
50
whether
states
it's
will
listed
disagree
on
with
the
each
form.
other as to whether there was an
So
insurrection
is it fair to say that
and whether
that
there was
affirmation is
he
like a
engaged in it
catch-all affirmation?
through his words.
I'd say that's fair, yes.
And you have similar catch-all affirmations for other non-presidential
And
candidates
that's what makes
on
this
their
fundamentally stupid.
candidate statement of intent?
Every candidate would sign an affirmation that they meet all qualifications for the office they're seeking.
No one was charged with insurrection.
If a
I
candidate
suspect
checks
that
the
was a
boxes
rhetorical
on the
question you were asking,
form
but it's an
under
important point.
qualifications for office and signs the affirmation, what, if any, additional inquiry does the Secretary of State make?
Our office isn't going to further investigate that affidavit. It's on its face, complete and accurate. And so based on that would certify a candidate to office, or to, I'm sorry, to the ballot.
That is correct.
And as you testified a moment ago, a Colorado voter could challenge that determination of the Secretary of State, correct?
Yes, that's correct.
Are you familiar with the 22nd Amendment to the United States Constitution?
I mean,
I was gonna say,
generally,
isn't their
I
job to
haven't
determine the
read it recently.
competency of Biden? Is that
Um,
another thing? Whether he's incapacitated?
Well,
This is so stupid. And then we'll have 50 different states
can you
arguing
state
about that.
generally what your knowledge of it is?
It would be helpful to see it.
Yeah. Well, I'll just represent it to you. Because generally what it says is the president can't hold more than 2 terms as president. Do you have any questions or do you accept my description of the 22nd Amendment?
We should
Has
start
the
challenging
Secretary of
New
State ever
Jersey to keep
received
Biden out
a
because he's
statement of
mentally
intent for a
incapacitated.
presidential candidate who has already served 2 terms as
We'll have
president
50 different states
Not to my
deciding that.
knowledge.
from, say, Barack Obama or George W. Bush?
No, not to my knowledge.
And what would the Secretary of State's office do in that situation?
Well, I think that knowing that both of the potential candidates you named have served both terms, I think that the ballot access team would escalate that within the office to the administration for additional guidance. But likely we would not certify that candidate to the ballot.
When you say elevate to the administration, give me just a little description of what that means.
Sure. So when the ballot access manager or the ballot access team received paperwork and there are questions about whether an eligibility provision is met and it's not clear, we will escalate that through our legal team within the elections division to the Deputy Secretary of State for additional guidance.
Okay.
It will be raised in
You
all 50
testified a few
states.
moments ago about how sometimes if there are eligibility questions, you engage in dialogue with the candidate. Would you engage in dialogue with George W. Bush or Barack Obama on that point?
I think we'd seek some guidance from the Deputy Secretary before corresponding.
All right, let me ask you some specific questions about the pieces of this form that were filled out by the candidate. Who submitted this particular form?
Donald Trump.
And when did the Secretary of State's office receive this form?
If we could scroll to the top.
Oh, sorry. There you go.
We received it on October 11th of 2023.
I put the link there.
And turning to the applicant's affirmation, down at the middle of the page, who signed the form?
It appears to be Donald Trump.
And what, is the signature properly notarized there?
It is.
In your reading of this form, has the candidate verified the applicant's affirmation? At the middle of the page there, that affirmation that you read.
Yes.
And what did your office do when you received this form?
Our
If
office,
you could like here before you go to
the
Rumble, I
ballot
appreciate
access team escalated a question to the deputy secretary because there's ongoing litigation with respect to this applicant's qualifications.
it. Yeah.
And so
So-
has your office taken any action with regard to certifying this candidate to the ballot or not?
We have not. We're not at the certification deadline, and it is our practice that when there is an ongoing legal challenge to our office's determination about a candidate's qualification, that we wait for that outcome.
Okay, let's turn to page 3 of that exhibit. Just the next page. There we go. Do you recognize this document?
Yes,
And what is this?
this is the state party presidential primary approval form.
And what's the purpose of this form?
The purpose of this form is for the state party to advise our office that the candidate seeking party nomination is a bona fide party candidate.
And who created this form?
The ballot access team within the elections division.
And how long has this form been in use by the Colorado Secretary of State?
Since 2020.
And was it similarly revised this year?
Yes, we would have revised the suite number and the email domain as well on this form. And the date.
And
Dak.
at the top where it says party contact information, what is shown there?
That's the contact information for both of Colorado's major political parties.
And so that contact information may also have been changed since 2020, correct?
Yes, that's correct.
Has the same form been used by the Secretary of State's office regardless of the political party of the Secretary of State?
Yes, this form has only been used, this will be its second presidential primary in use.
Okay. And the last presidential primary, who was the Secretary of State?
Wayne Williams? Is that right? Am I correct?
Just to confirm, who has the authority to revise or edit this form?
The ballot access team within the elections division.
Okay, now let's talk about the content of this form in terms of who filled it out. One moment here.
So, yeah, my point is That's the difference between self-executing
gonna
versus
just
not.
ask you a
Self-executing
clarifying
something all 50 states will
question on
universally
the
agree on almost all the
Presidential
time.
primary in 2020.
The rare exception I can think of is
Who was the
Obama's
Secretary of State then?
citizenship.
Jenna Griswold was secretary in 2020.
At least as of 2008.
Okay, who submitted this form that you see on your screen?
Donald Trump?
If you look at the bottom of well, let me ask you about that. Why do you say Donald Trump submitted this form?
That's the candidate listed.
And so the information on the bottom of the form is, what is the information at the bottom of the form?
It appears it was submitted by the campaign representative for Mr. Trump and signed by the state party chair.
And so does the candidate actually submit this
Are you gonna
form
show this?
as well?
C-SPAN?
It's submitted by the candidate's
Very useless.
campaign typically.
Come on, C-SPAN.
Yes.
But not submitted by the state party?
No.
C-SPAN's useless.
And at if we look at the bottom half of the page, it says state party use only. Do you see that?
Yes.
And can you tell us who is the party official that submitted this form?
Dave Williams?
And what is
I don't
his
make people
official
fight. I
job
bring people
title?
together.
Uh,
That's how I have
Chair of
the
the state party?
following. I'm bringing people together with community unity,
asked
greater
that 'cause
personal growth.
That was not a trick question, and maybe you can't see it, but it does say that on the bottom of the form, so well done.
It's cut off on my screen. I see it now. Yes.
Okay, has this particular form been modified by any of the persons filling it out from its original template?
It does not appear to have been.
Okay. And what did your office do when you received this form?
We
We
cringed.
placed this
It's a
via
damn it.
candidate paperwork for this candidate.
We all started
What
cussing.
happens if a candidate doesn't submit this form?
Then we communicate with the candidate that this form is required before we can certify them to the ballot for the presidential primary.
And you testified a few minutes ago about that the state party.
The
has
objective of this
to,
witness is try and prove that
approve
the Secretary
that
of State has
candidate
the
is a
authority
bona
to
fide
reject
candidate. Do you
someone
remember
if
that
they do not
testimony?
Yes.
comport
What
with
does it mean to be a
constitutional
bona fide
requirements.
candidate?
That's one of the issues the judge wants to decide.
I
So,
don't know what that means to the party.
she's a clerk
From our
of the
perspective, it
Secretary
means
of
that the party
State,
approves
And
that
she's
that
talking
candidate represents the
historically,
party.
what have they done with other candidates and how this whole process works in their office. So should the petitioners are trying to say, you see, the Secretary of State does keep people off the ballot. It's not something that's just for Congress to decide to remove someone.
What position is
The
the
Secretary of
Secretary of
State
State's office
is supposed
taking
to
in
do
this
that.
litigation?
It is the Secretary of State's office position that the paperwork is complete and final, but there is a challenge to this candidate's qualification. And so our office will not certify this candidate ballot until the court makes its decision.
And if this proceeding ultimately results in a determination that Mr. Trump is eligible to be a candidate for the Colorado presidential primary, what will the Secretary of State's office do?
The Secretary's office will certify the candidate.
And similarly, if the outcome of this litigation is that the case is dismissed without further guidance from the court, what will the Secretary of State's office do?
I can't speculate as to that. I think we need to wait for the court's outcome before we make a decision.
Ms. Rudy, are you aware of any threats that the Secretary of State's office has received regarding
Objection,
election
relevance.
activity?
Your Honor, I'm going to object to this. It's well beyond the scope of what we were notified as to her testimony, and it's frankly irrelevant to this case.
This is why you watch with me.
What's the relevance?
Well, the Secretary of
I don't
State's office,
know.
I think, has
I don't know.
a lot of knowledge about threats
How is that
to
relevant?
election officials in the state.
How is that
And
relevant?
I think the relevance here is that those threats can be tied, and I will try to tie them to some of the January 6th activity.
That's ridiculous.
I'm going to sustain the objection.
Yeah.
It's outside the scope of this hearing.
Yeah. Yeah. This is why you watch with me.
Oh, as a housekeeping matter, Your Honor, I want to move to admit P-158, which is the document on the screen, which was stipulated into evidence. I just didn't move it.
Okay. I'm sorry, what was the number?
P-158.
Exhibit 158 is admitted.
May I have just one moment?
Let's see if she pulls it up there. If she pulls it up, I'll try to share it with you.
No further questions, Your Honor.
Okay. Oh my gosh, look at this woman. God. Yeah. Yeah. Oh God, look at her. This is not a good angle for her. It's within 30 feet.
Morning, Ms. Rudy.
Good morning.
How are you today?
Good, thanks.
Good. So I'm going to ask you a few questions.
That's Scott Gessel.
I believe I have cross-examined you at least a few times in the past 2 decades or so. So I'll just, if you don't understand a question that I have, please just ask me.
And make sure to speak into the microphone, Mr. Gessler.
Certainly.
Gessler.
If you don't understand a question I
Scott
have, just
Gessler.
please ask me to repeat it. Let me start with, in preparation today. So you did not speak to any members of the petitioner's attorney, correct?
That's correct.
Okay. Did you speak about your testimony with anyone in the Secretary of State's office?
I did.
And who is that?
Deputy Secretary Beal.
And tell me what your conversation was with him.
In what respect?
Describe the conversation. What topics did you discuss?
We generally discuss the topics that I could expect to speak about today. And
Did you talk to him about the secretary's position or lack thereof of a position with respect to this litigation?
we discussed this litigation and we discussed my testimony today. Yes.
Okay. And as part of that discussion, did you have a discussion with him as to what position you would describe with respect to the litigation?
What do you mean by what position with
Well,
respect to the
you
litigation?
testified earlier that the secretary is going to, wait for the court's outcome.
Oh, I'd missed that.
And you also
Thank you.
testified as to the meaning of the form.
Yeah, the Secretary of
Did you
State
discuss
is
either of those
pretending
two
to be
issues with
very
with Deputy
neutral
Secretary
here,
Beal?
but they're hoping.
I generally shared
Petitioners
with
win.
him what my answers to those questions were. Yes.
And when you gave your thoughts as to what those answers were, did he tell you what perhaps his position was or his thoughts on that, or what the secretary's thoughts were?
Apart from saying that he agreed with the position that I was stating, no.
Okay. Did you have any conversations with the secretary herself on this issue?
I did not.
Okay. Do you have any conversations with the director of elections, Judge Choate?
I did not talk with Judd about this. Yes.
Okay. Okay. Did Mr. Beal inform you as to what the topics were going to be for your testimony today?
Yes, Mr. Beal and counsel.
Okay. And did he walk through, did you provide all of your answers that you anticipated giving today? Did you provide those answers to Mr. Beal as well?
Yes.
Okay. Did he ask you to change your opinion in any way?
He did not.
Okay. Okay, let me ask you, you had testified a little bit earlier about the 3 methods for a major party presidential candidate to get on the ballot. Do you remember that?
Yes, in a presidential primary.
Okay. And you said to get on the ballot for a presidential primary, there was the party nomination process, the petition process, and then the affidavit plus fee process, correct?
That's correct.
So I will tell you, my read, I didn't quite understand what do you mean by the party nomination process?
That's the process of filing the candidate affidavit, the party form of bona fide party candidate, and the application fee.
Okay. How does that different from the filing of the affidavit of intent and the fee?
The third affidavit of intent and the fee is for a write-in candidate.
Okay, for a write-in candidate for the party nomination.
That's correct.
Okay. Let me ask you this. So and I was just wondering, so the form, we may bring it up, but the form that, the statement of intent form, that was created in 2020, correct?
That's correct.
Okay,
Well, 2019 ahead of the 2020. primary.
in preparation. Was there any rule or regulation setting the contents of that form?
No,
Okay. And you said earlier that the ballot access team has authority to modify that form.
that's
Right.
correct.
Did the ballot access team create that form?
They did.
Okay. And did they have full authority to create that form?
They did.
Okay. And so that form is essentially created by the ballot access team, correct?
Yes, that's correct.
Okay. And I want to chat with you about the qualifications too. So there's I want to chat with you about the congressional form. Are you familiar with the fact that the congressional form also requires a person to check 3 boxes for eligibility?
I've not recently looked at the congressional form. If I could see an example of it, that would
Okay.
be helpful.
Because I'm afraid of the technology, I'm going to see if I can describe this to you. I'm going to represent to you that one of the boxes that the candidate checks says inhabitant of state. Does that refresh your memory, or do you still need to see the form?
It would be helpful if I could see the form.
Fair enough. Your Honor, can we take about a minute break? I'd like to just pull up that form, please.
Sure, while your team is finding that form, can you
Just continue the, sure.
move to another topic and then come back?
Okay.
Krabby T-Girth, is this the lawyer from yesterday that was so good? Yes, this is Scott Gessler. And he was great. I don't know how much, I mean, this witness, there's not much you can do with this witness. She's simply telling you factually what the Secretary of State has done in the past. There's really not much room you can attack her on this.
There we go.
Oh, we have it.
Maybe there's a few points you want to get out of her, which you feel are beneficial based on historically how the Secretary of State has handled
All right, do you
various
see that form in
elements.
front of you, Ms. Rudy?
Yes.
Okay. And that,
So this is the write-in form.
I want you to take a look at the write-in form. That works
Okay.
fine. And the second box says inhabitant of Colorado, correct?
The second box under qualifications for office says that, yes.
Okay. And in order to, does that mean that the person has to be an inhabitant of Colorado at the time they fill out that form?
No.
We verify that they are at the time they fill out that form, yes.
That they are an inhabitant of Colorado at that time?
Yes.
Okay.
For president?
And is that would you agree with me then that that's the office's interpretation of federal requirements to qualify for the ballot, that they have to be an inhabitant of Colorado?
I don't think that's the sole qualification for that office.
I understand, but it's the office's interpretation that that's one of 3 required qualifications for them to be on the ballot. Is that correct?
Yes.
Okay. And would it be fair to say then for the presidential candidate form, it's the office's interpretation that to qualify, the candidate has to fill out the 3 requirements, specifically that they're a natural-born citizen, 14-year resident, and 35 years of age?
Yes, the form must be fully completed, each of the boxes checked, and the affidavit affirming that they meet all qualifications for office must be signed and notarized.
Okay. And the statutory basis for those three requirements is there a statutory basis for those three requirements in Colorado law that you can point to?
Are we talking about the presidential form?
Presidential form.
Yes, there's a statute that tells us that we give effect to the federal qualifications for office.
Okay. And is that the same statute that you rely on for this, the qualifications for this write-in form?
Apparently,
If you could bring the statute back up again, please.
I'm not going to kid you and say that I knew what steps you have to take
You had said there was a federal statute. I'm sorry, there was a state statute.
to run for president. I've never tried it myself,
Can you tell me what state statute that is?
but
I
apparently,
don't recall the specific citation,
I wonder if the
but all of the
perhaps in all
qualifications and
50 states.
requirements for the presidential primary are contained within Article 12. I'm sorry, within Part 12 of Article 4, beginning
Okay.
with 1-4-1201.
Okay. So it's the 1-4-12, the 1201, the 12 series of statutes that set forth the statutory basis for those requirements.
That's correct.
Okay. And then for these three requirements for the write-in candidate, for the United States representative candidate, where it says at least, I think that says 25 years old, inhabitant of Colorado. And then the third item, is there Colorado statute that requires you to requires the office to include those three as well?
I don't recall off the top of my head, but the provisions for becoming a candidate in Colorado for Congress or Senate are set out in a different area of the law.
Okay. Is it the office's practice that you need a state statute to include those three, or you can just, or you look only to the US Constitution?
The office is required to certify eligible candidates to the ballot. And so wherever those eligibility requirements are set out is where we look.
Okay. And so that's the office's attempt, that's the office's approach in establishing what the qualifications are for a candidate. Creating that form with those three boxes.
Again, that's not intended to be an exhaustive list of qualifications for office, but yes, we list the primary qualifications for
intended to be
office.
exhaustive.
And then each candidate signs an affidavit that they meet every qualification for office.
So there could be more qualifications.
That's where you're
for
seeing the
this,
lean.
Affidavit.
There are
of
other.
intent for
We
a
just
write-in
left it off the
designation
form.
that are not on this form.
There could be.
Okay.
Could be.
And you're saying that's the intent,
about
and it has been the
competence?
intent of the office since you've been there?
Yes.
Okay. And the basis for saying that that's the intent is the affidavit write-in. What's the evidence that you're relying upon to say it's the intent? Is it your memory, or are you able to point to something else?
I've worked in the office for 17 years, and that's been the practice since I have worked there.
Okay. The practice has been for the form to not necessarily include the form itself, to not necessarily list all of the requirements for an office holder. Is that correct?
That's correct. In the past, the form required the candidate to list their qualifications for office. The inclusion of checkboxes was intended to help candidates out to identify their specific qualifications.
Can you identify any other forms in the office that have requirements, but that do not list all of the requirements on the form itself?
As I sit here now, no, our office produces quite a number of forms.
And you produce those forms to be able to provide guidance for a candidate, correct?
We produce those forms to provide guidance for candidates, campaigns, parties, voters. Our office produces quite a number of forms.
Do you produce those forms to be binding legal authority as well?
I'm sorry, what do you mean by that?
Do you produce those forms to be binding legal requirements for candidates as well? So is the information required to be filled out required for candidates under law?
In order to gain ballot access in Colorado, a candidate must complete fully their paperwork before they submit it.
Okay, let's talk about going behind the paperwork. So you're familiar with the controversies involving the natural born citizenship for President Barack Obama when he ran in 2012. Is that correct?
I read the news.
Okay. Did that rise to the
Okay.
level for the office to investigate whether President Barack Obama was in fact a natural born citizen?
Our office never received any formal complaints or requests to consider that information.
Okay, so that wasn't quite my question. You earlier said that if you have affirmative knowledge that a candidate does not meet certain requirements, you'll keep that candidate off the ballot, correct?
Correct.
Okay. And so if someone comes to you and says, I have evidence that this candidate is not 35 years old, will you keep that candidate off the ballot?
We would escalate that to the deputy secretary for guidance.
Okay. And do you know what the criteria are that the deputy secretary of state would follow for that guidance?
If we have affirmative information that a candidate is ineligible, it is the office's view that the secretary can refrain from putting that candidate on the ballot.
Okay. So if someone were to come up and say, I have affirmative evidence, here's evidence that this particular candidate is not 35 years old, what do you do with that evidence?
I can't speculate as to hypothetical, not knowing what that evidence is. That would have to be the discussion with the deputy secretary.
Okay. And then the deputy secretary would make that decision as to the quality of the evidence?
The deputy secretary, the secretary would advise the division as the best manner to proceed.
Okay. And the division would follow that advice, correct?
That's correct.
Okay. So the deputy secretary of state or secretary would instruct the division on how to proceed, correct?
That's correct.
Okay. And so the secretary and deputy secretary themselves would sort of personally would evaluate the quality of the information that you received, correct?
The ballot access team would seek that guidance from the deputy secretary. That's correct.
Okay. And do you know whether or not the deputy secretary of state and the secretary of state would then evaluate the quality of that information?
Again,
I'm going to ask you to hold off for a sec because we have sirens. It's been the pattern of practice in this courtroom. Do you need me to repeat my question?
please.
Okay. So do you know the criteria that the secretary and the deputy secretary of state would use to evaluate the quality of that information?
Again, I can't speak to a hypothetical situation.
I'm not asking you to speak to a hypothetical situation. I'm asking if you know what criteria they use to evaluate that information.
Since we're not in a situation where we're applying those criteria, I can't speak to what criteria they would use.
Okay. Now let's go back to the that write-in candidate form, please. Okay. So if I fill out, let's say I decide to have a temporary bout of insanity and I decide to run for US Congress as a write-in candidate. And I fill out the form and I say, I am not an inhabitant of Colorado, but I will become an inhabitant at the time I'm elected. Would you allow me to run? Would the office allow me to run for office?
We would escalate that to the deputy secretary to have a discussion.
Okay. I'm going to represent to you that the US Constitution explicitly requires a member of Congress as a qualification to hold office at the time they are elected. With that information, does that change your answer?
Again, I can't speak to hypotheticals. We would escalate that for a discussion with the deputy secretary before making a decision.
Okay. And it's the secretary or the deputy secretary that would make that decision?
We would seek their guidance before making a final determination, yes.
Okay. For Hassan, if I remember correctly, you testified that Hassan never submitted the paperwork, the statement of intent, correct?
Yes, that's my recollection.
And that was a statement of intent for a write-in candidate, correct?
I don't recall specifically. Would it be possible to pull the letter back up?
Sure. I will represent to you that he was for a write-in candidate. Will you accept that representation, or would you like to take a look at the letter?
I mean, I prefer to take a look, but
That's
I'll
fine.
accept that.
Could we pull that letter up, please?
Yeah, I feel like this is like, I feel like he's like Scott's dancing here. Maybe he's got somewhere he wants to go, but I feel like he's dancing.
P 107.
His point with this question is, well, when you're saying that you keep people off, that's not a major party's candidate. That's some.
Just tell
people
us
who
if we
write
need to
in.
scroll down.
Yes, could you scroll to the second paragraph, please? I don't see that it's for a write-in candidate. Honestly, I don't recall.
Okay. Do you recall him being an unaffiliated candidate?
Yes, he was an unaffiliated candidate for the presidential election in November of 2012.
Okay. And he refused to submit the paperwork, correct?
That's correct.
Okay. So that did not, as a result,
It's not
you
really.
did not actually have to evaluate the paperwork because it was never submitted to your office, correct?
We did not have to evaluate the paperwork, but we corresponded with him with respect to his qualifications.
Okay. No further questions, Your Honor.
Yeah, that's.
Do you have some questions? Okay.
Ooh. This, I believe, is the intervener who is. Wait.
Good morning, Ms. Rudy. I'm Jane Raskin. I represent the Colorado Republican Party.
Yeah.
I just want to go back and make sure I understand the
They're on
procedure
Trump's
you
side.
described your office is following.
This is the first time they've asked questions.
In connection with a presidential primary election, it receives paperwork under what I think you described as the party nomination process.
Yeah.
Right. So in that instance, as I understand it, you typically will receive the major party candidate statement, the one you went over earlier. I think it was exhibit, 158. And that contains as an attachment, as I understand it, a document that's called the State Party Presidential Primary Approval.
We receive for presidential primaries for major party candidates, the candidate statement of intent, the party approval form stating that the candidate is a bona fide party candidate, and the filing fee.
Okay, so you now have those two documents in hand, say. What do you do? And those forms, as you have described, contain an affirmation by the candidate that he satisfies the requirements of law for the office he's seeking access to the ballot for, right?
Yes.
And they include specifically 3 boxes for the candidate to check, to which he affirms that he's 35 years old and a natural born citizen, and he's lived in the country for 14 years, right?
That's correct.
So you get that document and you get the companion document, which is the party's certification that he's bona fide a candidate of the party. What do you do to verify the candidate's affirmation that he is in fact qualified to hold the office for which he's seeking access to the ballot?
The ballot access team doesn't do any investigation beyond the the review of the paperwork to ensure it's accurate and complete, and to review the
That's
plain
hilarious.
paperwork to ensure that the
friggin'
approve
hilarious.
box as opposed to the disapprove box is checked.
And if those boxes are all checked, the paperwork is in order, you certify that candidate for inclusion on the ballot, correct?
Well, it depends on where we are in the timeline. We don't certify candidates to the ballot until January 5th.
Okay, so you may get the paperwork early, but you wait till shortly before the certification date to actually complete the certification.
We certify on the certification deadline.
Okay. And I assume that is in part to allow time for other interested parties to challenge the form if they want to, as you've described.
What is in time? I'm sorry, I don't
So
understand.
during the period of time after which you've received the major candidate statement and the party's certification that the candidate's bona fide candidate of the party, you've said that other people, whether it's a competing candidate or another party or another elector, can come in and make a complaint, either informally, say, hey, look, I think this guy, wasn't born in the United States, or alternatively can actually file a petition under 113, right?
That's correct.
So before you certify the ballot, you have this time period where those issues may be raised and may be resolved.
Those issues may be raised, but there are also other deadlines within that time period before certification for petitions and for the affidavit for write-in. Those deadlines come a little bit later.
No, I understand, but I'm just talking at this point about the process for a candidate nominated by a major party.
I understand, but you asked why we wouldn't certify until the deadline.
Let's stop pretending that we're talking about
So in other
some
words, what you're saying is
some
you
knucklehead
certify all
off
of
the
the
street
candidates the same day.
when we're
That's
assessing
correct.
So
Trump's
the others may
candidacy.
implicate that decision even if you already have the major party candidate. Is that?
Only major parties may be certified for the presidential primary ballot, but there are multiple ways to be placed on the
And
ballot.
no one cares
and those
about the
deadlines
multiple
differ,
ways.
So we certify
We're
all
not talking about the
candidates
multiple
for
ways.
both major
Stop
party
talking about the
presidential
multiple
primaries on the
ways,
same date.
Pinky.
Okay. So let's go
don't care
back to
about
the
that.
point
No
at
one
which you
care about
received the
that.
paperwork. And understanding you don't certify it until the deadline. If nobody comes in with any, what you've described, I think is affirmative information that there is something incorrect in the certification form, and no one has filed a 113, and you ultimately reach the certification date, it's the secretary's duty to certify that candidate to the ballot, correct?
That's correct.
Okay. So when you were discussing earlier that you got some forms and you verify the info is required by state law, you were talking about candidates for state office, right?
We review every form that our office receives. State law requires us to verify information for state candidate forms, and for presidential primary elections. We review the information on the affidavit itself. We're also required to verify that the party has completed the party approval form and has approved the candidate as a party representative.
Right, but for federal candidates as opposed to state candidates, you don't have an equivalent process to check any databases to determine residency or where the person was born or things of that nature, as you do with state candidates.
For presidential candidates, that's correct.
So when you testified earlier that, I think what you said was that the secretary is never the final arbiter
They beat the
of
chief.
whether a candidate is eligible to be listed on a ballot.
Yeah, they suck.
That's not the case if there is no challenge made to the
And when this case
request
was
to be
filed, they
included,
never thought
correct?
they would beat the Chiefs.
There's always an opportunity for the secretary's determination to be challenged in court, and in that case, the court is the final arbiter.
Sure, there's an opportunity, but if nobody places a challenge, nobody complains, nobody files a 113, then the final decision is made by the secretary.
That's correct.
That's pretty much her job. She's like the woman who works in the office in the DMV. It's like, no, you forgot to fill out Form 1064.
Just one more question. Has your office, to your knowledge, ever refused to certify
Major
a
party.
candidate for inclusion on the presidential primary ballot, understanding that it's been an
A
issue
former
for a short period of
president?
time?
Well, there are candidates that we've corresponded with,
See, this is a poorly worded
ahead
question.
of the 2020 election who failed to
Poorly worded question.
complete the paperwork. We've corresponded with a candidate ahead of this primary election, and they've failed to complete the proper paperwork.
Has there ever been an instance in which a candidate has completed the paperwork that your office has created that you have disqualified in a presidential primary election?
Not to my knowledge.
Boom.
That's it. Thank you very much.
That was a good final question. We never done this before. Never done it before.
Mr. Klarchuk, proceed.
Thank you, Your Honor. Just a couple of areas I wanted to follow up on, Ms. Rudy. You testified about Section 113 on your direct. Do you recall?
I do.
And you were asked some questions about when the official charged with the duty has committed or is about to commit a breach or neglect of duty or other wrongful act. Do you recall those questions?
Yes.
And you were asked specifically about when it might arise when a 113 would be brought before an election official, including possibly the secretary, has committed a breach or neglect of duty. Do you recall that?
Yes.
In the context of certifying a ballot on a certification date, do you have an understanding as to whether Section 113 challenges arise before an election official exercises their duty to certify ballot contents, or whether the challenge would come afterwards?
There are a lot of provisions in the candidate statutes that allow a challenge to a candidate's qualification if that candidate, for example, goes on by petition. There are very specific provisions that allow challenges to the secretary's determination. So typically those challenges arise under the statute that the candidate has followed to achieve ballot access.
And are sometimes challenges brought to whether a candidate will be listed on a ballot prior to a ballot certification deadline?
Yes.
And can those challenges be brought under, or have those challenges been brought under Section 113?
Yes, I believe some have.
I agree with you, KFG. That's exactly where she went.
You've also been asked some questions about instances where the Secretary of State's office has or has not certified a candidate to a presidential candidate specifically to the ballot. Do you recall those questions?
Yes.
Do you recall in 2012, and so we're talking before primary ballots, this would be a general election ballot. Do you remember a candidate with the last name of Wilson?
Yes, generally.
Do you recall a dispute around Mr. Wilson and whether he would be placed on the presidential ballot as an unaffiliated presidential candidate?
Yes, as I recall, Mr. Wilson failed to complete part of the paperwork properly, and we communicated with him and ultimately chose not to place him on the ballot based on his failure to fully complete the paperwork.
In other words, not relevant.
Okay, and what about in 2016, which again, this would have been for the general election, not for the primary, a candidate by the name of Denimore?
Yes.
Could you tell the court what you remember about that situation?
Similar to Wilson, Denimore, as I recall, did not fully complete the paperwork. even after our office corresponding with them, and we did not
Swing and a
certify
miss.
them to the ballot.
Swing and a miss.
And I believe you just testified a few moments ago about an instance that occurred in this election cycle for the presidential primary ballot. Could you describe a little more the circumstances around that?
Yeah, we received candidate paperwork for Joseph Maldonado, and the paperwork was not on the correct form. We hadn't updated and published the form yet. It wasn't properly notarized. It wasn't signed by the candidate
More
himself.
paperwork issue.
And so we returned the filing fee to that person and advised them that in order to seek access to the ballot, they needed to complete the proper paperwork, and that included the party approval paperwork as well.
Okay. Your Honor, that was it for my questioning. I know the court had some areas designated that I wanted to hear from a representative from the Secretary of State's office on. This is the only will call witness any party has listed from the Secretary of State's office, so I wanted to be sure that the court had any opportunity to ask Mr. Rudy any questions.
Why don't we finish redirect, and if my question isn't addressed, then I could ask him.
Thank you, Your Honor.
And Your Honor, I'm going to have one or two follow-up questions. I think we respectfully may have gone out of order based on the posture of the parties, but if I could just have an opportunity after Ms. Tierney is done, I would appreciate it.
Why
So
don't
that guy
you
was from the Secretary of State's office.
Do yours so that then she can
That's fine.
wrap up with a redirect.
So this is
Ms. Rudy, just very quickly for Mr. Wilson, Denimore, and Maldonado, all of those were rejected based on their failure to complete the proper paperwork. Is that right?
Yes, that's correct.
Okay. In your experience, has there ever been a presidential candidate who has completed the proper paperwork yet been kept off the ballot by your office?
As I sit here today, I can't think of a specific example, no.
Okay, thank you.
there you go. Now we go to redirect. I apologize for that confusion. Different parties dancing
Ms.
around
Rudy,
here.
you answered some questions from Mr. Gessler about the forms in the office. I just want to follow up on that briefly. He asked you who generally drafts the forms, and I think you said the ballot access team. Those forms are then reviewed by somebody else in your office for compliance with the law,
Reading.
correct?
Our legal team may take a look at the forms if there are substantive legal changes to those forms. So if qualifications have changed, or if it's the first instance of a form. But if we're updating addresses, things like that, it will just be the ballot access team.
But the first time a form is created or
Leading.
if substantive changes are made, there is a further review of the form beyond the
Leading.
ballot access team.
Yes, that's correct.
You also, just want to follow up on that confirming that your office, as you testified on direct examination, follows both state and federal law when determining candidate eligibility?
Yes, that's correct.
And even if the federal qualifications may not be spelled out elsewhere in state statute, correct?
Yes, that's correct.
And on direct examination, we also had a colloquy about the 22nd Amendment and what your office would do if George W. Bush or Barack Obama submitted a statement of intent. And you testified at that time that you would escalate that. And Mr. Gessler, I think, asked you some questions about what escalating means. In that situation, when you would escalate that question,
This is all
if
one
it were
question.
to be determined by the office that the George W. Bush or Barack Obama was ineligible based on federal constitutional qualifications, would you keep them off the ballot?
If that was the determination, yes.
And conversely, if for some reason you kept him off the ballot and somebody challenged that eligibility or the secretary's determination to keep them off the ballot, and a court decided that they should be
It's a-
placed on the
It's an
ballot,
outright lie, by the
what
way.
would your
There's no
office
way
do?
they would have done that.
We would certify the name to the ballot.
I have nothing further.
So, Ms. Rudy, you can, if you don't know the answer to this, it's totally fine, but what would you do if, well,
Judge
first
asking
of all,
hypotheticals now. Great.
is it your understanding
I'll go
that
back to where it is.
if the Secretary of State's office, the ballot access team, all the way up to the Secretary of State wanted to add a checkbox to address the 22nd
Speculation. That's what the
amendment, so
judge is
it
looking
said,
for.
you know,
This is judge questioning now.
you haven't been president more than 2 terms, would that be within, is your understanding?
Why the
something
hell
that
is the judge
Secretary of
asking such a
State's
stupid
office could do?
speculative question?
Yes.
And then my other question is
It's so
similar.
stupid.
If
A leading speculative question.
if Barack Obama
What an
were
idiot.
to
What a clown.
President Clinton.
This is where you're
were
leaning on the
to,
scales here,
submit
woman.
a statement of intent.
This is so wrong.
And check check the
Dude.
boxes that are on there.
Dude.
Regardless of what they
Dude.
are, and sign it.
Leading speculative question
nobody
designed to get
filed a
elicit from
lawsuit.
her a reason to hang
In
your
your
hat that
estimation,
this is
what-
totally
what-
in her
just what
office
would
when
the
she has no
process
knowledge
be,
whatsoever.
given
It's totally
that,
speculating. Yeah,
presumably
sure, that's what would
whoever's
happen.
reviewing that would know that President Clinton had
This is
already been
this is so
president twice.
gross.
Again, it's hard to speak to hypotheticals, but certainly the ballot access team would
hypotheticals. This is
escalate
what
that
the
through
judge
the
is
legal
asking.
team to the
Stupid
Deputy Secretary
hypotheticals.
for guidance. But given that that is an objective, knowable
You
fact.
can't object to a question
it's
the judge is
unlikely that we
asking.
would certify that candidate's name to the ballot.
If anybody have any follow-up questions?
FJB, F this case, and F this judge for even hearing such a
Ms.
deliberately
Rudy, I just want to ask
biased.
you a question.
Oh,
So,
crap. Just saying. Thank you, Joe.
so the court asked you a question and you said, with respect to the term limit, and you said if it's an objective, knowable fact, you'd feel comfortable or you'd predict that it would be likely that the office would not allow that person to appear on the ballot. Is that correct?
In the situation that we discussed, yes, that's correct.
Right. And because the 2 term limits, that's an objective, knowable fact, correct?
Yes, we know that they've served 2 terms.
Right. So you know this case is about the 14th Amendment, correct?
That's correct.
And is it your understanding that Congress can remove any disability to holding office under the 14th Amendment?
I understand that.
Okay. And would you agree with me that sitting here today, even if a court, whether in Colorado or elsewhere, were to hold that President Trump was disqualified, even in that highly unlikely situation, would you agree with me that it is not an objective, knowable fact as to whether or not Congress would in the future remove that disability?
Objection, Your Honor. I don't think the witness can testify to that.
We're talking about what's a noble fact.
I'll let her testify to the extent she knows the answer, but she's not designated as an expert on this
The
subject.
judge's way of saying, say, I don't know.
I really can't speak to how our
That's what the
office would
judge just
handle
told her
that
to say.
situation.
Okay. Let me ask you this. Would you agree with me that it's not an objective, knowable fact, sitting here today, how Congress will react in any way between now and the presidential election in 2024?
Maybe they'll
I would
pardon.
say that, as with any area of law, it's impossible to know how a
Any area of the
legislative body
future.
will act looking into the future. I can't speak to how they will behave.
So
Great. Thank you very much.
the point being, you don't know that you're
Does
going to
anybody
keep him
else
off the
have any
ballot. You don't even know if
follow-ups?
Congress is going to say we're excusing him from this. You don't know that's not going to happen.
No, Your Honor.
Great question. Great question by
Okay,
Scott
great.
Gessler.
Thank you so much for your testimony, Ms. Rudy.
Thank you.
Am I correct in understanding
great
that
point.
Ms. Rudy was the petitioner's last witness?
Your Honor,
Congress can't waive the 35 years old. They can't waive natural born citizen. They can waive the 14th Amendment. You don't know that they're not going to waive the issue on the 14th
thank you, Your Honor.
Amendment.
We
with
have one
Trump on
witness
this
who is
particular thing.
testifying out of order
why
on
would a
Friday. That's
Secretary of
Mr.
State-
Heafy.
Okay.
And we also have some exhibits that we are reworking to submit, the January 6th findings in particular, so that we are submitting only those Your Honor has found to be admissible,
Mhm.
to clean up the record a little bit. And then we may want to highlight additional documents that are already admitted into evidence that we might submit. But other than those three items, Mr. Heafy, the January 6th findings, and some additional highlighting, we are completed.
Okay.
So they're done with their case.
Mr. Gessler, do we have anything we need to discuss before you call your first witness?
Yes, Your Honor, we'd
Well,
like
that's
to
going
move
to
for a
the
directed
defense.
verdict. We understand that Mr. Heafy is going to be testifying on Friday, but it's our understanding that he's testifying at the request of this court, specifically for the admissibility of the January 6th report. And for purposes of our motion for directed verdict, we will assume that the January 6th report is fully admissible. And so we would like to move for directed verdict and have the opportunity to make that case, Your Honor.
Just going to deny.
Okay, are you prepared to do it right now?
I am indeed.
Well, good.
So now he's going to present his case to establish why they have not established
Your
their
Honor.
case, and she must, as a matter of
So
law,
we
remove.
move for directed verdict under Rule 50 here. And we're moving on very focused grounds, specifically with respect to the whether or not President Trump incited anything under the Brandenburg standards, under the First Amendment. And so basically, for purposes of this, we're accepting everything that the petitioners have provided in evidence, as well as we're accepting obviously for limited purposes, the admissibility of the January 6th report. I just want to walk through the evidence, what you've received, apply what are very straightforward and well-established legal standards. And we believe this case warrants dismissal at this point because the petitioners have not made out their case on this issue. So as the court knows, there have been a number of arguments raised with respect to Section 113 and 1204. This directed motion is not involving that. There have been a number of arguments we've presented with respect to the interpretation of Section 3 of the 14th Amendment. This directed motion is not focused on that. What it is focused on is the Brandenburg standards, the definition of incitement. Our argument under Section 3 is that President Trump has to engage in an insurrection. Petitioners have argued that incitement can constitute engage. Although for overall purposes, we don't accept that, we disagree with that argument. For purposes of the directed motion, we will operate on that premise. So the evidence that the court's received so far, and in totality, has been the January 6th report, or portions of the January 6th report. It received evidence from Officer Hodges, and he testified to activities, the violence and things that happened at the Capitol. He did not testify to President Trump's actions. Representative Caldwell, he testified to activities that happened at the Capitol as well, from his perspective. He did not testify to President Trump's activities, beyond simply saying he heard the speech. And Representative Caldwell, of course, testified to things in prior years. Mr. Pinjan testified again, very similar to Officer Hodges' activities at the Capitol. You have Professor Banks, who testified as to what President Trump's authorities were to mobilize the National Guard on January 6th. He did not testify to President Trump's actions at all. You have Professor Magliocca, who testified as to the meaning of Section 3. He did not testify to President Trump's actions. And importantly, he did not testify as to the meaning of intent or the applicability of the 14th Amendment. So his testimony for purposes of this motion is not relevant. And then you heard from Ms. Rudy, who testified as to the Secretary of State's authority, of course, much different than President Trump's actions. So basically, there's two things. One is information from the January 6th report, and the second is Professor Simi's
There you go.
Professor Simi's testimony with respect to far right-wing extremists. Neither one of those shows that President Trump in any manner, in
An
any way,
intent.
incited
Or inside.
an insurrection, incited violence, incited a riot.
Simi didn't even talk
Not
to
at
any of
all
them.
under the well-established Supreme Court standards of Brandenburg versus Ohio. This case is entirely, petitioner's case is entirely a case about President Trump's speeches. His speech, his Twitter video. That's the entire body of their evidence. And that's the entire body of evidence from the January 6th report. They don't allege that President Trump was, had meetings with Proud Boys or 3%ers. They don't allege that he, carried a knife or a rifle or marched at the head of a column towards the Capitol. They don't argue that he engaged in any of those sort of physical overt actions. It is all speech. That's the entire body of their case. And if you remember, the petitioner sort of had this chart up here towards the end of Professor Simi's testimony, and he talked about this speech and that speech. Oh, there it is, over in the corner there. All of that stuff that President Trump did. And of course, they sort of have a pejorative memory aid, the punch in the face or the body slam or the stand back and stand by. But those are all things that President Trump said. Every one of them is about him saying something or not saying something. He didn't condemn activities in Georgia or Charlottesville. He didn't say something. So it's all speech. We've submitted the speech standards under Brandenburg versus Ohio. I'm going to talk briefly, I don't want to be too pedantic, but I'm going to talk briefly about some of the applicability, okay? And particularly Professor Simi's testimony. So Professor Simi was very clear. He testified that he was not opining about President Trump's intent. He said, I'm not in President Trump's head. I don't know what his intent is. He said, what I can say is that I think his behavior is characteristic of communications with right-wing, far right-wing extremists.
Nobody's testified about his.
And he was very clear that President Trump's speech was interpreted in a particular way by these right-wing extremist groups. And as you remember, I questioned him. We had all these sort of fight in the streets from political figures other than President Trump. And I asked him, were those right-wing extremist communications? And he was very clear. It depended upon the relationship, the patterns of behavior and things like that as to how right-wing extremists would interpret the comments. So really his testimony was President Trump said stuff and right-wing extremists interpreted it in a certain way. And specifically when he said right-wing extremists, he referred to those three groups. He also said that the characteristics of these communications are in common with normal political speech. He talked about the communication methods, what he called double speak and front door, back door. And I'm sure he made us all feel uncomfortable that when we go in for a job interview versus when we talk to our significant other, we are engaging in double speak or maybe front stage, backstage. But one of those methodologies. So he testified about that. But the important thing he said was that all of these forms of communication, all these methods of communication, call and response and things like that, are common in political discourse, are commonly used in political discourse. And the difference with far right-wing extremists is that they couple it with violence. That was sort of what he said. And of course, he was very clear that many of these people interpreted President Trump's comments. So that's how Professor Simi testified. So let's apply that to the law. Okay, and I will talk about a few things. So the James versus Meow Media Inc., that's 300 F3rd 683, and that's in the Sixth Circuit. And in that case, the argument was that basically there was sort of an ongoing process of developing a method of communication.
Which Brandenburg excludes that.
And that after a while, the person hearing the communications was conditioned to to respond in a certain way. And the court was very clear, and I'll quote it, said, this glacial process of personality development is far from the temporal imminence that we have required
Under
to
Brandenburg.
satisfy the Brandenburg test.
Yes.
So you have to have the temporal instance.
In
or
time.
imminence.
Temporal means
So
in time, close in
All of
time.
the stuff that
Inside, it
Professor
must be
Simi
close in
talked
time.
about does
Not
not meet
months
First
earlier.
Amendment standards, all the prior conversations, the years, the pattern of development.
Nothing.
That has been explicitly
And that's why he
rejected.
hasn't been charged criminally for that.
Rejected by the courts. It has to be imminent, okay? And it can't be communication that, whether, even if it advocates, and none of these communications advocated, which I'll get to that, but it has to be imminent. And so Professor Simi's framework of this pattern of behavior, it may apply to how people received those communications, but it doesn't
apply in the-
constitute
in the
First
Brand-
Amendment standards. And
Right.
we think those standards are very, very clear.
He's laying this out very
The
well.
court also said that
Building blocks.
that the
building
mere
blocks here. That's
tendency
what you're
of
listening
speech
to
to
him do.
encourage unlawful acts is not a sufficient reason for banning it, absent some showing of a direct connection between the speech and imminent illegal conduct.
Right.
So even if speech advocates something, even if it encourages it, the tendency to encourage it is itself not an absent reason,
Free speech.
absent a showing of a direct connection between the speech and the imminent illegal conduct. So there has to be a direct connection. So President Trump saying, come on January 6th,
It'll be
will
wild.
be wild. That is not a direct connection between the
It's a day
speech and
earlier.
imminent illegal conduct.
Days or weeks earlier.
And we submit pretty straightforward case law. Now,
And I'm sorry, that's still the,
James versus Meow Media, and they have a number of citations in there. The pin site is page 698, Your Honor. And they cite Ashcroft versus Free Speech Coalition and McCoy versus Stewart in the quotation block that I'm referring to. But it's a great case. I suggest it for everyone in the audience to read. The second case, and I'm not going to be awfully pedantic. I don't want to provide an entire legal brief here. But I am going to talk about a couple things. Two more cases. Hess versus Indiana, and I believe we cited, that's a U.S. Supreme Court case from 1973. And there has to be evidence or rational inference from the import of the language that the words were intended to produce and likely produce imminent disorder. Okay?
so
They,
Mr. Kessler, would you just slow it down
certainly, Your
a
Honor.
little bit?
I'm mindful of time. I guess that's why I'm talking
No,
quickly.
I'd rather you slow it down so I could actually absorb what you're reading.
Fair enough, Your Honor.
versus,
Let me
Try to-
give.
He's building a
Let's start
record.
again with
He knows
Hess
she's going to
versus
deny it.
Indiana.
He's
Hess
building a
versus-
record
that's
for appeal.
414 US
So when she
105.
rejects it,
Okay.
he can appeal it.
And Hess
That's what he's doing
says
here.
there have to be a couple things. There has to be intent.
He doesn't really worry
In other
about her
words,
because
words
he
have
knows
to
she's
be
going to say no.
intended to produce, and they have to be likely to produce imminent disorder. And they could not be punished by the state on the ground that they had a tendency to lead to violence. So you have to look at the import of the words, their direct meaning, not a particularized coded meaning. And in fact, Professor Simi never testified that President Trump intended. In fact, he disavowed any testimony of President Trump's intent. And Professor Simi was very clear that the words used, no matter who's using them, whether it's the term fight or something else, have an impact on the listener depending upon the circumstances. It's all contextual.
He admitted he didn't even know if anyone
Here's the
heard
last
him.
case, and I think this case is really dispositive here. And the case is Dwanguma versus Trump. Dwanguma versus Trump. And that's spelled Nwanguma versus Trump. And that's 903 F3rd 604. And this is why this case is so dispositive. This was a rally involving President Trump, the same one who's here today. And he spoke at this rally. And this is described in the case. And And President Trump spoke for about 35 minutes. And Nwanguma, she attended the rally with the intention of peacefully protesting. Okay? And her behavior precipitated directions from President Trump to the crowd on 5 different occasions during that speech for her and a few of her colleagues to get him out of here. That's what he said. Get him out of here.
This is why he brought this up with Simi. 'Cause he knew
And
he had this
you, the
case.
court, heard video of how President Trump delivers those comments, types of comments, not this video in particular. He said, get him out of there. And in response, what happened is the crowd, members, this is quote, members of the audience assaulted, pushed, and shoved plaintiffs. And one of them was actually punched in the stomach. And the argument was
He incited
that
them.
that this implicitly encouraged the use of violence. Now, President Trump said a few other things. He said once, after his 5, get him out of here, he said, but don't hurt him. Actually, the case doesn't say but, it says don't hurt him, is what President Trump said.
This is the case he's talking
Okay.
about.
And what the court did, a couple things. The court said, even if the get him out of here could have viewed as implicitly encouraging unwanted physical touching. So the court didn't accept that it implicitly, didn't rule that it implicitly. Said even accepted the charge in Kentucky law that this case was inciting to riot. So it was incitement and riot, both of which we urge are lesser standards than here, but certainly incitement. And the court said the notion that Trump's direction to remove a handful of disruptive protesters from among hundreds or thousands in attendance could be deemed to implicitly incite a riot is simply not plausible. Even in those circumstances, and this is, Your Honor, why I was very careful to submit a very specific hypothetical to Professor Simi when I was asking him questions. I asked him, well, if President Trump were to say 5 times, get him out of here, and this crowd, even if it were filled with right-wing extremists, and then later and said it 5 times as opposed to only 1 time that don't hurt him. So I went through this exact hypothetical. And even
He was
Professor
preparing
Simi, he
for this.
hedged a little bit and he said, well, it still sort of depends on context.
He's wrong
Okay.
on law.
And so he wasn't quite willing to say, yes, that was an incitement to violence. But the court here is very clear. That is not an incitement here. It says incitement to riot, okay? And the court focuses on the incitement prong of that. Even there, the court was very clear. That is not incitement. And then the court especially went on and said, especially where any implication of incitement to riotous violence is explicitly negated by the accompanying words, don't hurt them. If words have meaning, the admonition, don't hurt them, cannot be reasonably construed as an urging to hurt them.
This is what he's reading now.
So what the court did there is the court, and I don't want to say the court rejected Dr. Simi's thesis, because the court didn't say, well,
Did Dr. Simi testify in this case?
Yes, today, all day. Where
no,
were you?
I'm sorry, Professor Simi. Did I say doctor?
Well, he said doctor and then I said doctor and I'm sure.
may be a
I'm
doctor,
sure he
too.
has a doctorate.
He said doctor.
I don't believe he did.
Oh, did he
But
testify in that
I don't
other
believe he did.
case?
But what I'm saying is, Professor Simi has said, well, the words can be reasonably interpreted there. The court doesn't accept that framework for a First Amendment analysis, which is what controls here. So I'm not saying he's wrong. I mean, right-wing extremists they very well may usually do that. But I'm saying from a constitutional objective standard, what the court does is the court looks at the objective words. Okay. The court went on as part of its ruling and it said, the fact that audience members reacted by using force does not transform Trump's protected speech into unprotected speech. The reaction of listeners does not alter the otherwise protected nature of speech. So in other words, the courts and we look at the objective meaning, the plain language of terms. We do not look at how those terms may be interpreted by the audience. Okay?
When I speak. I'm not sitting.
And they
you don't
later
sit here
said in
assess
that
my
same
speech
case,
based on how
it is the words
they're gonna
used
say
by
it.
the speaker that must be at the focus of the incitement inquiry, not how they may be heard by a listener. So again, we look at the words itself.
and not just
Okay.
twist them exactly 180
And then
degrees.
and
the way Simi
the
does.
case sort of cites a substantial amount of case law. I'm not going to cite all that
Trying to find the quote that
because I do want to keep this motion short. So we're not talking a difficult leap of faith to understand the applicability of Nwanguma versus Trump. In fact, I'd submit that the petitioner or the plaintiffs in Nwanguma versus Trump used, I don't exactly know what they argument, but I'm assuming very similar arguments to petitioners here, because they talked about the objective use of the words. The court rejected how they're interpreted by listeners. You have to look at the words themselves. In that case, get them out of here. Even that, the court was unwilling to accept as incitement. And the court was very explicit saying that
This is a great
it was
case.
negated.
And he
And of
set
course,
this up
we have other courts
last 3
talking
days,
very much
this
about
argument.
the incitement. And we cited some of that in our motion, even particularly provocative, directive language, very foul language in the cases, directed at audiences, and even that far closer in time than what we have here, was treated as not imminent. So under the imminence standard, absolutely nothing that President Trump said prior to January 6th would constitute incitement. And the most they've been able to come up with is the "will be wild" tweet. That's the most they've been able to come up with.
Well, what about the ellipse speech?
I'm getting there.
Oh,
I'm fixing to get there.
okay.
But I said prior to January
Oh,
6th.
I'm sorry.
Okay. So what I'm saying is that's a pretty easy analysis. Under the imminence prong, none of that stuff counts. Which brings the petitioner's case to one item, which is the ellipse speech. And absolutely nothing in there, none of President Trump's words were a call to violence. And look, if the Nwanguma court says,
Get him
big
out of
crowd, protesters in there, crowd angry, get them out of here 5 times, direction to the crowd, focused on that person or those few plaintiffs.
And then he gets beaten the
demanding
crap
that they
out of him.
be removed, get them out of there. If the court doesn't accept that as a call to riot, as incitement,
This is much
there's
less.
no way that when President
he
Trump
said the
says,
ellipse.
we need you to fight for our country, we need you to march down on the Capitol, there's no way that is incitement. And then, of course, the peaceful and patriotic. Now, look, the petitioners have seemingly developed an argument that, well, he didn't explicitly say, be peaceful and patriotic. President Trump merely said, I know you'll go down there peacefully and patriotically. But he emphasized peacefully and he emphasized patriotically in that speech. And under the same
They emphasize, you mean, in what way?
he
Sort of
he
paused.
made strong words. He talked about it vociferously, and it was towards the end of the speech and the penultimate, what we are here to do today. I am with you. I'm going to go down there with you peacefully and patriotically. And, and so he created a common sense of purpose as the, penultimate culmination of his speech. That's why it was towards the end. And so that certainly negates as well any violent intent.
The same
So
way.
the words themselves,
same way when he said,
the
"Don't hurt him."
objective meaning and objective use of the words,
Not
there is no call to
not the
violence.
sarcasm that Simi reads into it, but the plain words.
And everything that Trump says, fight, is a common political metaphor,
Even
meaning
Swalwell himself admitted he
a
uses.
political fight. And Trump on multiple occasions says, we're going to go down there and we're going to give our representatives courage. We're going to demand that Vice President Pence do the right thing. And obviously I'm paraphrasing. I'm happy to repeat the speech if the court wants, but you have it in front of you, a transcript. And you can look at those words. And under an objective meaning of those words, none of them are incitement. Then the last argument that they make
The tweet he made sent
is that President Trump failed to do enough to stop the riot once it started. Okay, so they have sort of three, within the world of speech, the evidence, they sort of have three components.
Look how
First component is
clearly,
all the stuff
how
in
clearly
advance of
he's
January
breaking
6th.
things down.
Doesn't meet the
There's
eminence.
pre-January 6th. There's the
Second component
lips,
they have
and
is the January 6th speech. And they say that's what incited. And even their own evidence, even quoting from the January 6th
Like a
report, the
baby
January
could
6th report
understand
says the
this.
violence started well before President Trump finished
so
his
well
speech.
done. So well done.
So that
Amazing work.
part of the violence, he certainly didn't incite with the January 6th speech. And then their argument is, well, he failed to stop the ongoing violence. And that's inaction, which has never been held to cause incitement. And even, and it's not an overt voluntary act. There's no evidence of that. And even this court has required specific intent. And there's no intent that President Trump's absence, what they call an absence. I mean, we dispute that factually. There's tweets in there where he says, be peaceful, stay peaceful, and then a video. I mean, 3 communications. And of course, they say that's not enough. And under the Brandenburg standards, though, it's not even close to enough. That's not incitement. So that's our motion for directed verdict, Your Honor. The court has not yet ruled on these First Amendment issues, and obviously we're asking the court to rule on it at sort of what I always call halftime motions. But it has been pretty thoroughly briefed, and the reason I waited was to see what evidence. I mean, maybe they had evidence that Trump was on the phone with Proud Boy saying, go. I mean, maybe they were to bring some evidence in there that, you know, he was sitting in a room and they were plotting out, you know, where people were going to stand and do it. But there's none of that. It's all speech. And so even on the grounds of speech, what President Trump did that day is not incitement under very well-established First Amendment principles, Your Honor.
This was phenomenal.
Are you
That was phenomenal.
prepared to respond now, or do you need a few minutes to regroup, or?
Your Honor, we're
Regroup.
happy to start now, but I think, you know, given the time, it might be better to give us a few minutes over lunch.
So
Give
this
us
is
an
where
hour.
I am, is that I'd like to rule after lunch. And we did start 20
So-
minutes late today.
so give it to me.
so, I
Give it to
think
me now.
Mr. Gessler spent about 15 minutes. So if you think you can respond at the same amount of time, we would just probably
Give it to me now is what you
break
just,
it.
just say it.
12:30 to 1:30 for lunch.
That's fine, Your Honor. Thank you.
Okay.
As we just heard from Professor Magliacca, to have engaged in insurrection means any voluntary act by word or deed in furtherance of the common unlawful purpose
But
of the
Brandenburg.
insurrection.
But
The
Brandenburg.
14th Amendment is not limited to incitement. It includes any voluntary conduct, including specific acts of encouragement that further that common end.
But
President
Brandenburg.
Trump was not just a part of the insurrection on January 6th, he was the leader of the insurrection. He summoned the mob with repeated tweets identifying January 6th as the time to descend on the Capitol. We've seen from both the written evidence and the testimony of Professor Simi the effect that Trump's statements and tweets in advance of January 6th had on mobilizing violent extremists to come to the Capitol ready to fight. And he did that using violent language. Just hours after he tweeted, "Come to DC, we'll be wild," he retweets from a right-wing
back.
extremist website a video chanting "Fight for Trump" over the course of over a minute, just to be sure
That's not him.
that
being
his
excited.
supporters would have no doubt what his intentions were. Second, his lies gave the mob their common purpose. Beginning well
Fuck
before the
Brandenburg.
election and leading up to it, he repeated claims that the only way he could lose the election was if it was stolen. And immediately on election night, he began repeating those same claims, even after court rejected his
What he
lies.
says
And
in,
even after
on election night
advisor
has
after advisor
nothing to
told him
do
there was
with
no
this?
basis
Nothing.
for those claims of fraud.
Nothing.
He created a false and desperate expectation in his supporters that the only way by January 6th they could overturn the results of what they thought were a stolen election was through force and violence. Third, he incited the mob with his speech at the Ellipse. And President Trump repeatedly wants to suggest that his speech was all about being peaceful and patriotic. But here's what we know. We've introduced findings from the January 6th report showing that President Trump had been briefed well in advance of his speech on the Ellipse on the fact that tens of thousands of his supporters refused to go through the magnetometers because they were armed. Despite knowing that, Trump used violent
there were 4
language
people charged with being
referring to
armed.
fight or some version of that 20 times.
Tens of thousands.
He told his supporters they get to go by a very different set of rules because fraud was involved. That is an implicit call to violence.
No, it's not.
That based on a long-standing pattern of call and response that he had developed among his supporters, he knew and his supporters knew were intended as a command to go beyond the normal rules of political
Insanity.
engagement.
Insanity.
He told them, you do not take back our country with weakness. And he repeatedly painted a target on the backs of Vice President Pence and members of Congress. And he told the mob not only that they should go to the Capitol, commanding them to go, but told them he would be right there with them because he knew that telling them that would encourage them to go to the Capitol prepared for violence. That's classic incitement. The cases that President Trump cites are fundamentally distinguishable. The Nagamua case was a case where Trump simply said, get him out of here, with no violent rhetoric. The plaintiffs in that case identified no other context that suggested that his words were likely to be taken as a command to violence at the time.
Is the
That
problem.
is
The
not
problem you
what
have
we
is that
here.
the
We have
glacier. You're trying to
months
use the
of
glacier against
context
him.
showing what Trump
The
was
months
telling his supporters to do on January 6th and why they were supposed to be there. And nobody in that case said, fight like hell and fight, fight, fight.
Oh, what about
There's a
Maxine Waters or
fundamentally
Chuck
different
Schumer or a
situation.
whirlwind of hate that's going to bring down on you?
Fourth, Trump incited the mob during the attack with his 224 tweet against Mike Pence. This was an hour after he learned that the Capitol was under violent attack and that members of Congress and the vice president's lives were in danger. And he told them, Mike Pence didn't have the courage to do what needs to be done. USA demands the truth. In context, USA demands the truth means the mob that is pounding on the doors of the Capitol demand the truth. They're not going to stand for the certification. They're going to stop it. At the very least, a reasonable fact finder could draw these inferences about what Trump
No, they
intended.
Not that that's
in
called. That's
issuing
not that's called to
that
do
tweet.
violence.
And fifth, Trump refused to summon a federal law enforcement response to stop the mob or to call the mob off until it was clear they were not going to be successful in disrupting
This
the
is such a lame-
certification.
this is
The
such
evidence
a
we've
lame
introduced,
case.
including findings from the
This is such a
January
bad
6th committee, make clear that it was that after 4 o'clock, it was clear that the certification was not going to be disrupted.
Oh my
Members of Congress had reached safety. Reinforcements had arrived through no effort of President Trump's, and the insurrection was starting to wind down. And it was at that point and that point only, after 3 hours of watching TV, that President Trump finally told his supporters to go home. Now, President Trump's defense is that this is just inaction. This isn't action. But it's a very well-established principle of law that inaction can support a finding of wrongful conduct when there is an affirmative duty to act. When does an affirmative duty to act arise? Well, number one, when there's a legal duty to act. President Trump swore an oath, the most powerful
swore
oath
an
anywhere in the
oath.
Constitution to preserve, protect,
But the
and
Capitol is
defend
under
the
Nancy's
Constitution. That is a
jurisdiction.
legal duty to act. You also have a legal duty to act when you've set the events in motion. And certainly we've seen that Trump did that here. And we're prepared to provide additional authority in our proposed findings of fact and conclusions of law, demonstrating
Yeah,
that these are the
that's my
kinds of
point.
circumstances where there is a duty
That's
to act.
stupid.
But what else does his inaction show? It shows that he intended
You're on the
the
same mindset as
results
somebody
of
else.
the insurrection, that he intended that the insurrection achieve its ends. Because when everybody is telling you you have to do something and you're the most powerful person in the world and you do nothing, that tells us you want them to succeed. I'm pulling up Plaintiff's Exhibit 78, some of the findings from the January 6th committee. And if we go to page 150, excuse me, page 46, finding 150, which the court has previously said was admissible.
I don't know how anything is admissible from the
Evidence
report.
from the committee's
Complete
investigation showed that the
Complete
president,
hearsay.
when told that the crowd was chanting "Hang Mike Pence," responded that perhaps Vice President Pence deserved to be hanged. And President Trump rebuffed pleas from Leader McCarthy to ask that his supporters leave the Capitol, stating, "Well, Kevin, I guess these people are more upset about the election than you are." What clearer evidence of specific intent to incite and aid an insurrection could you ask for? President Trump's defense is that the First Amendment protects his conduct here.
No,
But we've
that's
seen
the
that
Supreme
his
Court's
conduct was
defense.
not just incitement. His conduct was speech adjacent to criminal conduct, mobilization, organization. We've also seen that his conduct falls within the words of the 14th Amendment. And so Trump's argument appears to be that the First Amendment displaces the 14th Amendment, but there's no legal authority for that at all. And as we've laid out in the opposition to
Brandenburg is
President
kind of
Trump's
legal
anti-SLAPP
authority.
motion, that simply cannot be right. The 14th Amendment does not impose any criminal penalty. It simply provides an additional qualification for office. And there is nothing unconstitutional about enforcing that qualification, even if the
I guess.
insurrection activity comes by word. But in any event, the standard for incitement is clearly met here. Number one, President Trump advocated explicitly or implicitly unlawful violent action. We've seen that he called for the crowd to fight like hell, to go by a very different set of rules.
Like every other politician.
We've also heard evidence providing context for what those words meant to Trump and to his supporters through a long-standing pattern of call and response in which he could speak in coded language because his supporters would understand exactly what his coded language meant. That was the testimony you heard from Professor Simi, and I would direct the court's attention to the Seventh Circuit case in United States versus White, 610 F. 3rd 957, in which the court said that threats or incitement need not be in explicit terms. They can be also in coded language that is intended and understood as a command to violence. And that's exactly what we saw with President Trump's speech on the ellipse. And that's exactly what we saw in his tweet on 2/24. And of course, the second prong of the incitement standard is that the speech was likely to incite imminent lawless action. And of course, that was true here. Of course, you had a crowd of tens of thousands of people, half of whom refused to go through the magnetometers because they were armed or carrying prohibited items. Those are from the findings in the January 6th report that we've introduced. This is like summoning a mob out in front of someone's house where everyone has pitchforks and torches. And you don't say, go burn down the house, but you give a speech that makes it pretty clear to everybody exactly what you're telling them to do. That's classic incitement. So then Trump's last defense is he didn't intend it. He incited insurrection accidentally. But of course, intent can be inferred from circumstances and from conduct. And the court doesn't have to check their common sense at the door when determining what Trump intended by his words and his deeds. And you have to look at the whole context and not just take one word of his speech out of context.
Yeah,
We heard Professor Simi
no one said
testify
that.
about Trump's
No, the court never said that. Even in White, when they say
encouraging
intent,
and
the
praising
intent
political violence
itself,
and cultivating a relationship with
coded
violent
language.
extremists. There's a reason we haven't seen political violence on this magnitude in the US in response to speeches by President Obama or President George Bush or Nancy Pelosi or Mitch McConnell. Other leaders don't talk this way, and they don't keep
They
talking
all
this way,
talk this way.
when they see how their violent supporters
Look at this.
respond to the words they utter. Now, we saw
This is
Trump
the coded language.
retweeting the
It's not
warning by
coded
a Georgia
language.
election official, Gabriel Sterling, about how someone was going to get killed as a result of his violent rhetoric and his refusal to call off his supporters. And we saw that his response to that explicit warning was to double down. And that's not the action of someone who is concerned about violence. How else do we know what Trump intended? He thought Vice President Pence deserved it, finding 150 that we've previously looked at.
The coded
We
language
also
in the
saw
case-
his
case
tweets
he's citing
after the attack on January 6th.
is right
These
there.
are the things that happen when an election is unceremoniously ripped from his victims. He was praising the violence, remember this day forever, because he was in league with the insurrectionists. And we saw what he was saying even years later, that fraud allowed suspending all rules, including the Constitution of the United States. That was his mental state on January 6th, and that was his mental state even years later. He has violated his oath. He engaged in insurrection. Thank you.
The coded language was the guy threatening by
Do
saying,
you
"I-
want any more argument from me, Your Honor? I'm not insulted if you say no.
I think we should,
gonna say no.
you want to say something? Well, Mr. Klarchuk, you have said so little, unlike some other folks that I'm gonna give you a chance.
Your Honor, it's just nice to say something other than my name and no questions. Just very briefly, Your Honor. Rule 50 is inconsistent with a 113 action. The idea behind a 113 is we get an expedited resolution of this process. We get it all bundled up and it goes up on appeal for the Supreme Court to consider whether they want to hear it or not. I think if you consider how this could play out, if the court were to entertain a Rule 50, is if the court were to grant the Rule 50, we could end up in the Supreme Court on the 3-day expedited appeal. Supreme Court could say,
Oh,
actually,
God.
you know, after
This is
a lot of
Secretary of
briefing
State's
and all that,
counsel
say, actually, you know
saying,
what?
don't give a directed
We think
verdict.
the district court erred.
This
It should not have
procedurally
granted
can be
the Rule
messy.
50. Let's go back down. We then have a
What a
whole half
schmuck.
of this case we would still have to try. And all of a sudden, January 5th is looking really close.
What a schmuck.
When the secretary is going to have to make a
Secretary of
certification decision. I'd point the court to Rule 81 of the Colorado Rules of Civil
What a
Procedure,
schmuck.
which say that when a special statutory proceeding, which 113
This is the Secretary of
undoubtedly
State's
is,
office. This bastard.
provides its own procedures, and the rules of civil procedure are inconsistent with the special statutory proceeding, the court should follow the procedures of the special statutory proceeding and not those of the rules of civil procedure. Rule 50 talks about a directed verdict. There's not a verdict at the end of a 113 action, Your Honor. There's an order directing substantial compliance with the election code. So we just think that this Rule 50 motion is procedurally improper and should be denied on that ground. Thank you.
Do you have case law to support that? Do you have case
Okay.
law?
I'm going to take it under advisement and hopefully have something to say in response when we reconvene at 1:30 today. And Mr. Gessler, you'll be prepared with your first witness?
Yes, Your Honor.
When I deny your
Last
motion?
housekeeping thing, for tomorrow, we have a witness who needs to start at 1 o'clock. So if we can just do that as part of the planning process, I want to give you that well in advance.
Well, you've gotten it 3 times already today.
That's a notice to pay particular attention to what I'm saying.
Okay. Okay, we will, why don't we just make it 1:35? We'll be back.
Okay.
He said it was an equal opportunity. It hasn't been equal opportunity.
Is that a guy with a yarmulke on there with Gessler?
Want that extra time?
We don't.
It looks like a guy with a yarmulke. All right.
Will I be able to see things?
Oh, hot mic. Hot mic.
What?
Hot mic.
Yeah. Okay, great.
Oh, great.
Oh, great.
No,
Okay.
I'm on.
So we're going to turn this off here. So just to share with you here, what he says is like, oh, coded language can be incitement. It can be incitement. It can be illegal. Oh yeah, this is the coded language. A guy in this white case that the petitioner side was, what he said was, I would very much like to avoid an incident in which something violent potentially happens to you. They're like, yeah, that's still a threat. That's still a threat. That's the coded language. And they're saying because the court in the Seventh Circuit said that this is something you could be held liable for. Will you make some agreements, sell the issues of money, and with my access to my daughter? If I don't hear from you within 24 hours, then the files will be on you. I've done everything I can to work this out peacefully. That was the coded language in white, which they said, yeah, your coded language, we can see through your code. It's not a coded language. Anyone hearing that understands what it is. Anyone hearing that understands what it is. It's like, okay. That's the same thing as like when Trump says patriotically, what he really means is patriots murder Congress. Oh my God. Oh my God. Unbelievable. Unbelievable. So she's going to deny the motion. That's almost certain. It's almost certain. She's, first of all, she's donating money to organizations that want to punish Lauren Boebert and the Republican committee for accepting Trump as a candidate, right, and not denouncing him as an insurrectionist. And there was a motion for her to recuse herself, which she's like, oh, I don't remember making that donation, so I'm not going to recuse myself. Yeah, you know what? I got to tell you this. I don't remember making a lot of donations. There's a lot of donations. I made a lot of donations I don't remember making, okay? I'll tell you this. Even though I don't remember making a lot of donations, there's zero chance I donated to some anti-insurrectionist fund. Zero. I can promise you. You can look through all my records. I'll tell you right now, zero chance that I ever donated to that. Zero. I don't remember making that donation. So I don't really care about it that much, and that's why I'm not recusing myself. Anyhow, but that's where she's leaning. So that's what I'm telling you right now. Is she going to reject this motion for directed verdict? 100%. I would be astonished if she accepted it. Astonished. And she even said as much when she's like, is your first witness going to be ready at 1:30 after I finish giving my opening remarks wherein I reject your motion. But she just left out the last 4 words of that sentence, or last 5 words. But so that's where she's at. The reason you bring this motion is because this preserves your right to appeal. He's not talking to her, and that's why he didn't really care if she heard him, because he knows what she's going to say. He knows she's going to say no. But you need to go on the record and say this in order to preserve it, preserve the record, and that ends up going up to the appellate court and basically saying these are all the legal reasons that this crazy woman who should have recused herself got the law wrong. When she allowed this case to even go further, it should have been wrapped up before the defense even took the stand, and the defense opened their case. So that's why you do it, not to win here, but to win on appeal. And I thought that he did such a great job of just laying out the bricks here as to like, this is what they said. There's all this glacial build up to January 6th, which cannot be part of Brandenburg. Then you have what he said, the ellipse, which we have a case on point, which basically is much worse language, much more overt language of get him out of here. That he's saying, get him out of here, get him out of here, get him out of here, which the court said was negated by the fact that he said, don't hurt him. And here he's like, we're going to fight like our country. He says, like every other politician, we're going to fight. We're going to fight for America. We're going to fight for America. And we're going to march here peacefully and patriotically. As the penultimate moment, that's why we're here, to march there peacefully and patriotically. And then this duty to act afterwards. I thought he did a great job. Phenomenal. Loved the work that he did there. Really did. Even though it's going to be rejected now, even though the immediate result is going to look like it was a useless waste of time, that's not the point. The point is for the appeal. That's what it's for. Now, the guy this morning, the witness this morning, did he look creepy and bizarre? Yes. Did he make some points that I thought were like, okay, you know what? That's a fair point as far as like why it is that you can legally interpret this as an insurrection. Do I agree with his findings? No, of course not. I don't agree with them at all. I think that some of the stuff that he's rejecting and the way he's twisting things around was clearly contorted. But not everything he said was stupid. It's just that what you need to remember is this. For the petitioners to win here, they don't need to win on this argument or that argument or this argument or that argument. They literally need to win on every argument. And the judge, in order to find in their favor, has to say the petitioners win on every single argument. So before we get into the defense, I just want to point this out to you. If there is a hole anywhere in any part of their argument, they can't strip them out there. If Section 3 of the 14th Amendment does not apply to a president, they lose. If January 6th is not deemed an insurrection, they lose. If incitement is not considered engaging in insurrection, they lose, and Trump goes on the ballot. If in fact if in fact he's not, you don't accept that this is coded language, they lose. If it's free speech under Brandenburg, they lose. So she has to basically say, everyone, you're right on that, 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 and that's why we're moving him from the ballot. Now, will she say that? My gut says, good chance she will, because I think that she started there. But long before they actually anyone was sworn in here as a witness, long before. I think that when she refused to recuse, I don't even think that this should have been in state court. This should have been in federal court. There's an issue of federal question as far as how we interpret the 14th Amendment. I mean, that's your classic federal case law. Oh, and the other issue is whether, I forgot, another thing they have to win on is the Secretary of State licensed to remove someone if they are ineligible. And is that really the same thing as an ineligible? Do we really going to compare an ineligibility because the guy is actually 32 and not 35, which makes you ineligible, or not a natural born citizen, not living here for the last 14 years? Are we really going to compare that to a easily debatable point about was this an insurrection and did he incite an insurrection so that he should be banished based on Section 3 of the 14th Amendment, which is something that you can easily foresee that if that issue is litigated in 50 different states, that'll be split 30-20 from this state to that state if every state were to go through this stupid exercise. And how the hell can you have a 14th Amendment that's going to be decided 30-20 by 50 different states? And that each state say, oh, we think it should be like this on the federal election. It makes zero sense, which is another reason it's completely different than like, is the person 35, which is something all 50 states will agree that person is over 35 or they ain't. So that's why to make the comparison there and say this is something the Secretary of State is licensed to remove, is licensed to decide on, or the court should be directing the Secretary of State as what they should do is a crazy comparison. And the judge has to say, no, it's totally in our license, along with all the other things in order for him to be removed from the ballot. She's got to decide, like, there's like 9 different issues that every one of them I'm ruling in favor of the petitioner, and that's why, and any of those issues that are not in favor of the petitioner, petitioners lose this case. It's this house of cards. And so many of these cards are made out of fluff, and some of them are holograms, and some of them are some decision from Tennessee from 1847, or what one judge said about what he thinks the definition of insurrection is. It's insanity. It's crazy. All right, let me, yikes. What else I was looking for here? I can get to my rants after I just finished going through that whole explanation. Okay, let me make sure I got this here. So I had a whole bunch from Krabby T. Girth. All right, Krabby T. Girth says, this guy has a common ability. He's talking about Scott Gessler. I bet that helps him get more out of the witness. I agree with you. There's so much I like about Scott Gessler. as an attorney, as a litigator. There's a lot to like about this guy, and his voice and his mannerism is part of it. It is part of it, because that's part of being an effective communicator. And people were commenting yesterday that he reminds them of Columbo. It's just sort of like this soft, just explain this to me, instead of ramming it down people's throats, which when you're in a courtroom, it's a very effective thing. He also asked, can anybody object to this question? I assume that when you asked this, you were referring to the questions that were being asked by the judge. Could you object to it? Yes, you could. You could object to a question the judge is asking. Say, I don't think it's proper for you to be asking a question of speculation. It's a way to really tick a judge off, because obviously she's gonna say overruled, and please answer my question. And so what are you going to do? You're going to appeal and say this was not a question that should have been asked, so that's why she reached her decision, because it gave an. It's just, you're not going to win that. So could it technically be done? Yes. Is it pragmatically? Is it a logical thing to road to walk down? Almost certainly not. And you're more likely to irritate the judge than you are to actually see any benefit out of it. So the downside, or potential downside, is far greater than the upside, even though it's very, very aggravating that the judge was so ridiculously biased to start asking this fact witness hypothetical questions about what would happen, and to speculate so much so that she says, well, I don't know, it's a hypothetical. Even the witness recognized that it was calling for speculation, which is what made it, which was exposing how ridiculous the judge's questions were. So she's a ridiculous judge. She's a joke. Gabby T also says, this guy's almost as good as you, Joe. He's really good litigator, and I take that as a big compliment. Thank you. And then Real Patriots Party says, Joe, notice you got late nights, including Friday, because Nick is on his way to Mar-a-Lago. We saw you accept the challenge last night. We never let you get off the hook. That's why you love us. Well, I don't know if he's on his way to Mar-a-Lago. I don't know that he said that, but I hope he has a good. I hope if he's going to Mar-a-Lago, he did say he's going to Florida. And I'll see what I can do as far as late nights. I need sleep. I need sleep. These sitting here assessing, engaging my brain for multiple hours a day. It's tiring. I know it looks easy. I want to thank you again, Randy. I'm going to give you this one more time. I agree with you. F this judge. F this judge. Cash says, Joe, Congress can waive the paperwork requirements because Pinky says so. Aren't Senate committee findings generally admissible in all courts? Aren't Senate committee findings? Usually you have to have someone who's basically substantiating it. It's not testimony. In other words, so in the committee findings, that doesn't mean that when a committee's findings that XYZ happened in this different place. I don't know. That's a really good question. I want to think that through. Sitting committee findings generally admissible in all courts. Why would that not be hearsay? Why would that not be a huge hearsay issue? If they're findings, they research and they basically say XYZ, I don't think that's actually true. Philosophically, it makes no sense why that would be an exception to hearsay. It shouldn't be an exception to hearsay. I don't know that I accept that as being accurate. I don't accept that as being accurate. I don't remember ever hearing something to that effect. I don't know. Maybe there's some law that overrides the general rules of evidence. To me, I don't understand why that would be. Because if you think about what the whole purpose of having something omitted as hearsay is, that you can't cross-examine them. You can't get context. You can't get anything. You don't know. It's an out-of-court statement that's made. That's not made out of. It's not under oath. Some schmuck writes in a committee report something, all of a sudden that now is something that the court's going to recognize as being a fact. That doesn't make any sense. I don't think that's accurate. I've never had to assess that question before, but I don't think that's accurate. That's why Benjamin Franklin was never president. Misfiled paperwork. Yeah, maybe. He was a really smart guy. He could have been. The reason I've never been president is because I've never filed the proper paperwork. That's the only reason. Although Ben probably was a closer candidate than I am. Thank you for the super sticker, Janie. I appreciate that. It's very thoughtful. A series of bats says, I'm very behind, but just to say, wow, that expert looks like a baby bird with a bent beak and ears for wings. Yeah, that was pretty frightening stuff. Not going to kid you. It was actually really frightening stuff. He had a face for radio. That's what they say. Failure of office in no way can be used. This is talking about his failure to fix things up. He has immunity as a public office holder. It's a ridiculous argument. This was when the kid lawyer was basically saying he didn't stop the insurrection once it was underway. And yeah, I think it's a pretty weak argument. I think it's a very weak argument, unless it's designed to reflect his state of mind, which is what I think. In that perspective, I can understand it being used. I mean, that's reflecting his state of mind, which is, to be fair, I think that's how he was pitching it. So it's not as ridiculous, but that itself would not be the insurrection. That's reflecting what his state of mind was when he made his statements earlier. I simply that he had the intent, but you still have the Brandenburg issue. That's the problem that they have. It standing alone, it wouldn't. To me, it's ridiculous. So I agree with you, NY Renal MD, that standing alone, it makes it. That's not a basis to apply the 14th Amendment to him. It's only can do to support theoretically as saying this reflects that when he was talking an hour earlier, his objective was to have this whole series of events unfold, and that's why he's not stopping it. So we want to try and use that as indicia of his intent when he made the statement an hour earlier. But the statement an hour earlier is the real problem. So for that perspective, I can understand recognizing, assuming he was engaged, he was inactive, I can understand logically why that would be a relevant factor. But that first statement, you got the Brandenburg issue, that the statement standing on its face, even if he has pure intent, even if he means for them to do it, he's thinking, oh, I want them to go out there. I want them to go inside. But the way he words it is the way that he words it, which no one would reasonably take is imminently means imminent incitement. Then even if he means it, doesn't matter. And that's the case law that he brought down there, that Mwangan case, which I don't know if I pronounced it correctly, but that's the best I'm ever going to get to. Kelly says Trump has been found guilty in court of sedition, insurrection, treason. We don't know if there is an insurrection here. No one's been charged with it. So he's basically being found as if like he's guilty of an insurrection that we've never established as a fact actually happened. No, case closed. Hurt some feelings. Made some people lose their minds. Yes, Your Honor. Have a nice day. Thanks for your time. Joe taking dog to the beach. Hope you have a great time at the beach. I wish I lived near enough beach. I wish I had a dog. Everything about that, I wish. I wish I had a dog. I wish I can go like running with a dog on the beach. That sounds so cool. That sounds so cool. I'm picturing like a golden retriever kind of thing. Man, I'm jealous. All right. Jonathan says, Judge, if you deal with the massive run, that was great. That's great. Some-year-old Bowser and Nancy Pelosi are guilty of insurrection as well, according to him. According to this dude, yeah. So compelled speech is the rebuttal. So I think I walked through that. TextFat says this guy is the Charlie Always Sunny in Philly meme. Map looking for the Pepe Silva LMAO. If you don't know it, please look it up. I don't know the. I'm a big fan of Always Sunny. But I'm not enough of an aficionado that I know this. He's got the map looking for Pepe Silva. Now I want to know Charlie.
They're on to me, dude. Those guys are on to me, dude. Those guys are sharp as nails up there. You can't put anything past them. Oh my God, dude.
I can't watch this with you. I'm gonna have this whole thing. I'll have my whole stream come crashing down. I know how those things work. Phil Vecchio says, from Charles I in Parliament to Napoleon in French legislature, sending armed troops into the legislature is often viewed as an attempted coup. Armed troops. Armed troops. Armed troops. Not armed troops. Not unarmed civilians. There's a big difference. I agree with you. If he sent in there like some battalion from, you know, from the Army, from the Marines, that's a coup. That's a very different thing than sending a whole bunch of tourists who are like, hey, I'm holding Nancy Pelosi's gavel. Here's her lectern. That's your coup. No, it's not the same thing, Phil. Incitement is a felony under federal law to intentionally solicit, command, induce, or otherwise endeavor to persuade another person to engage in a crime of violence against person or property. Not guilty of that either. Yeah, of course not. Of course not. I agree with you totally. And thank you for your big support, Kelly. Drop Barracuda says, so are they asserting that no doesn't mean no? Does no mean no? I guess that's correct. That's a good catch by you. That's a good catch by you. All right. I just want to be 100% sure that I caught everything. All right, I'm good there. I'm good there. I'm good there. This thing is starting at 3:30. Customize for each destination. Create live stream. And right now, I have already set up my 3:30 stream. If you on YouTube, I've not yet set it up on Rumble because Rumble doesn't allow me to set one up while it's ongoing. I am going to take a break for a half hour. I'll be back here at 3:30. We'll be watching it then. We tuned in then, but this is set up, and I am going to. And I'm going to be back at that time. Tina Lewis says, why is it never brought up in these stupid cases that Trump was never found guilty by the Senate of insurrection in the past impeachment? Why hasn't that been mentioned? It was mentioned. It was mentioned in opening statements. She's already rejected that argument. That's why they're not talking about it. But that's already been preserved for appeal. It's a great question. Great question. It was brought up in opening arguments, and she's like, you already brought this up in your papers. I don't want to hear that argument anymore. So that's why you're not going to hear it in this trial. But that doesn't mean it's not anything that's going to arise in the appeal, because that issue is already being appealed. It's a good thought. You're correct on that. Which is another issue that the petitioners have to win, and otherwise they lose. There's like so many different ways that it's like ridiculous to think that he's going to be kept off the ballot. It's like insane to think that he would be kept off the ballot because it's such a house of cards. It's such a house of cards. They have to be working really hard to try and find a way to use the 14th Amendment against him. And I don't think it will hold up. I don't think it'll hold up in a single state, not in Colorado or anywhere. I don't think it will. I think ultimately it's going to be rejected. I'm doubtful that it'll happen under this harebrained judge. So, all right. My stream is set up at 3:30 on this channel. Whether you're watching on Rumble or you're watching on YouTube, you will see it. I still need to set up the Rumble one. I'm about to set it up, but I'm gonna wrap this up right here. I'm gonna land my plane here. I need to take a few minutes and just sort of chill and grab lunch and stuff of that nature. I will see you all at 3:30. I thank you for joining me. I can't wait to see you in like 35 minutes. Till then, take care of yourselves. And as always, my friends, I say to you, Godspeed.